Last few classes left, two important topics to discuss. One, judiciary, and the other, elections. Today, let's discuss judiciary. We will be looking at Supreme Court and we will focus our attention on the Supreme Court. We will look at High Court as well, but purely from the mains perspective, with some facts here and there for prelims. And then there are district courts, there are subordinate courts. We will not focus on them, not too important for the examination. Whatever is important there, we will try to cover in the Supreme Court itself. But this is a very important discussion, very important for your examination. Listen to me carefully, calm down. Whatever doubts you have, you can always ask me later. But for the next 2 hours at least, don't ask me anything. Just listen to me, immerse into the world of judiciary. When we look at judiciary in India, we say we have an integrated judicial structure. What is this integrated judicial structure? We have district courts in all the states in India. In every district, there is a court known as the district court. In every state, or should we say, for every state, we have high courts. And it is not necessary that we should have one high court for one state. We may have a common high court as well, and we do have common high courts. But every state has a high court. Whether that high court is for some other state as well, that is regardless of the point. The point is every state has a high court. And then at the top, we have the Supreme Court. Clear? When we look at United States of America, because ours is a federal constitution and there is no particular definition of a federal constitution, then we look at the United States Constitution and compare the constitution to that of the US Constitution. If it matches, it is federal. If it doesn't, then it is something else. Because US is the oldest federal constitution, or considered to be the oldest federal constitution of the world. There, normally what happens, in India, if you file a case in the district court, any case for that matter, you lose that case, you can file an appeal before the High Court. You lost the case there as well, then you file an appeal before the Supreme Court. And there are various conditions that you have to satisfy, which we will discuss today. But very briefly, just for our naivety, you can file a case in the High District Court, lost it, appealed before the High Court, lost it, and finally you reach the Supreme Court. And whatever decision is taken by Supreme Court is final. But when it comes to the Supreme Court or the conditions of law in United States, you file a case in a state, for example, Chicago, for example, Michigan, for example, Illinois. Every state has its own Supreme Court. And all the cases end at the Supreme Court of that state. They have a federal Supreme Court as well in Washington, D.C., the federal Supreme Court, but it only hears federal cases. Federal cases in the sense, if there is a dispute between the center and the state, such case can be filed in the federal Supreme Court. If there is a dispute amongst the states themselves, such cases can be filed in the federal Supreme Court. That's it. But our Supreme Court takes up all cases, not just constitutional cases, not just federal cases, fundamental rights cases as well, marital disputes as well, property disputes as well, normal criminal crimes as well. Any kind of case can reach the Supreme Court through a route known as district court, then high court, then the Supreme Court. But that's not the case with United States. They have separated judiciary. That means there is separate judiciary for the states, and all cases, whether criminal cases, civil cases, they end at the Supreme Court of their state. There's a crime in Chicago. Ultimately, the decision, the verdict of the High Court or the Supreme Court of Chicago is final. But they have a federal Supreme Court as well. But it takes mostly the federal cases, constitutional cases. So they don't have an integrated judiciary. We have an integrated judiciary. They have separate judiciary for states and the federal cases. In India, we say we have an integrated judiciary because a judge of the district court over a period of time can be promoted to the high court. And a judge of a high court over a period of time can also be promoted to the Supreme Court. All these three courts, these are constitutional courts. And what do we mean by constitutional courts? These courts are created by the Constitution. First, we will look at Supreme Court, then High Court, then slightly a little bit information on the District Court, and then there is another structure, a fourth tier as well, known as Gram Nyayalayas. Those also we will discuss, but towards the end. First, let's focus on Supreme Court, and Supreme Court is something which is very important for your civil services examination. What is the Supreme Court? What is the composition? How the judges are appointed? What are their powers? And what is the current functioning of the Supreme Court? Let's look at it. Constitution says under Article 124, there shall be a Supreme Court of India consisting of a Chief Justice of India and not more than 7 judges. This is 26 January 1950. When the Constitution was enacted, Article 124, Clause 1 said, there shall be a Supreme Court of India with Chief Justice at its head and not more than 7 judges. Can we increase the number of judges? Yes. For that, what is required? Parliament will enact a law. And through this law, Parliament can increase the number of judges. Today, how many judges do we have? We have a Chief Justice of India and not more than 33 judges. These 33 judges are also known as brother judges or puisne judges. But this parliamentary law does not come under the amendment to the Constitution under Article 368. What does that mean? That means if the Constitution says there shall be a Supreme Court of India consisting of Chief Justice of India and not more than 7 judges, can we increase the number of judges? Yes. Have we increased the number of judges? Yes. And we have increased the number of judges multiple times in the past. And the current structure is we have the Chief Justice of India and not more than 33 other judges. And these 33 other judges are known as puisne judges. But what is the process of increasing the number of judges? Parliament has to enact a law, and this law, which is passed through simple majority, can increase the number of judges. But you are amending the Constitution. You are now mentioning that instead of 7 judges, we have 33 judges. Is this not amendment to the Constitution? Constitution itself says that if Parliament wants to increase the number of judges, it can do that. That won't be deemed as amendment to the Constitution. That means this is the provision of the Constitution which Parliament can change by simple majority, which means Article 368 is not required. Parliament can enact an ordinary law passed by simple majority to increase the number of judges. But how are these judges appointed? For that, we need to look at the qualification of a judge. In order to become the judge of the Supreme Court, one should be first the citizen of India. Number 2, if you are a citizen of India, then you have to meet one of the 3 criteria. You are a citizen of India and you are a judge of a high court. or one or more high courts for 5 years consecutively. You are a citizen of India, but you are also the judge of the High Court, one or more high courts for 5 years consecutively. You are qualified to be appointed as the judge of the Supreme Court. If not, you are the citizen of India and you are the advocate of a high court. You are a lawyer of the high court for 10 years consecutively, whether in one high court or multiple high courts. You have been practicing law as an advocate in one or more high courts for 10 years. You are qualified to become the judge of the Supreme Court. If not, then you are a citizen of India. And in the eyes of the President of India, you are a distinguished jurist. In the eyes of the President, but President does not have his own eyes or her own eyes. It's basically the eyes of the Prime Minister. If in the eyes of the President of India, you are a distinguished jurist and you are a citizen of India, you are qualified to be appointed as the judge of the Supreme Court. But who is a distinguished jurist? Maybe a law professor of a university who has taught law for 20 years, 30 years. He's basically a lawyer, but does not practice law. He understands law, the constitution, everything, but has not been a judge. Such an individual is a distinguished jurist. In the eyes of the President of India, if you are a distinguished jurist, you are qualified to be appointed as the judge of the Supreme Court. Or distinguished jurist can be anybody. Right now, for example, President Murmu is attending this lecture. She likes it. Says, in my eyes, you are the distinguished jurist. And you are also the citizen of India. You are qualified to be appointed as the judge of the Supreme Court. But I would say, madam, these are not your eyes. Shakespeare was wrong. Beauty lies in the eyes of beholder. It's basically the Prime Minister. So please talk to him. But be that as it may, these are the qualifications. Similar qualifications we have for a High Court judge. If you are a citizen of India and you have been holding judicial office for 10 years. I am the citizen of India, but I am a district judge in one or more district courts for 10 years. I am qualified to be appointed as the judge of a high court. If not, I am the citizen of India and I am practicing advocate in one or more high courts for 10 years. There is no qualification as that of a distinguished jurist when it comes to the appointment as a high court judge. That means who is qualified to be appointed as a judge? Judge can be a high court judge or a Supreme Court judge. Why are we discussing them together? Because their appointment process is same. Their removal process is same. For a Supreme Court judge, if you are a citizen of India and you have been a judge of one or more high courts for 5 years, you are qualified. You are a citizen of India and you are an advocate in one or more high courts for 10 years, you are qualified. You are the citizen of India and in the eyes of the President of India, you are a distinguished jurist. It means you are qualified to be appointed as the judge of a Supreme Court. Qualified. For a high court, you should be a citizen of India and you must have held a judicial office, let's say a district judge, for 10 years. If not, you are the citizen of India and you are an advocate in one or more high courts for 10 years. You are qualified to be appointed as the judge of a high court. That means a distinguished jurist can be directly appointed to the Supreme Court. That's the qualification. This does not apply to a high court judge. But now if Supreme Court consists of Chief Justice of India and not more than 33 judges, if these are the qualifications, what is the appointment process? How are these judges appointed? Constitution says under Article 124 Clause 2, and you don't have to remember these clauses, just understand the concept. Every judge of the Supreme Court shall be appointed by the President after consultation with such of the judges of the Supreme Court and High Courts in the states as the President may deem necessary. and shall hold office until he attains the age of 65. Provided, in case of a judge other than the Chief Justice of India is to be appointed, Chief Justice of India shall always be consulted. What does that mean? Original constitution said every judge, whether this judge is of a Supreme Court or this judge is of a High Court, who will appoint these judges? President. Which means this power is given to the executive. Judicial appointments are given to the executive. But the president will have to follow something, a process known as consultation. Every judge of the Supreme Court or High Court will be appointed by the president, and president will consult. Now, who is this president going to consult? Such of the judges of the Supreme Court or High Court as he may deem necessary. Which basically means, if the president has to appoint Chief Justice of India, the president can appoint me as the Chief Justice of India. Come, you are appointed as the Chief Justice of India. Somebody would ask, but did you consult anybody? President will say, Constitution says, every judge of the Supreme Court and High Court shall be appointed by the president after consultation with such of the judges of the Supreme Court and High Court as he may deem necessary. President did not deem it necessary to consult anybody. So without consulting anybody, I appointed this person as the judge of the Supreme Court. But if a judge other than the Chief Justice of India is to be appointed, Chief Justice of India shall always be consulted. If you have to appoint Chief Justice of India, President shall consult such of the judges of the Supreme Court and High Court as the President may deem necessary. But if other judges are to be appointed, other than the Chief Justice of India, this Chief Justice of India shall always be consulted. And this process is known as consultation. And this is where, over a period of time, we entered into a conflict. Previously, what would happen? Immediately after the commencement of the Constitution, till about 1970s, there was no problem. No problem in the sense, always the senior-most judge of the Supreme Court was appointed as the Chief Justice of India. And when other judges were appointed, Chief Justice of India was always consulted. Who is the senior-most judge? Senior-most judge in terms of experience at the Supreme Court. We have 33 judges. Chief Justice of India is dead, or he has resigned, or his term got over. Because you are holding the office till you attain the age of 65. After that, you retire. Now we have to find a replacement, successor. That means one of these 33 judges will be appointed as the Chief Justice of India. Constitution was not clear. Constitution said President can appoint a judge after consulting with such of the judges of the Supreme Court and High Court as he may deem necessary. But we were following convention. Convention, unwritten rule. Not mentioned anywhere, but something that we follow. And the convention was, out of these 33 judges, whoever is senior most will be appointed as the Chief Justice of India. Senior most not in terms of age. Senior most in terms of experience at the Supreme Court. What does that mean? My age is 50. Your age is 45. Okay? And by the way, my age is not 50. I'm much older. For example, I'm 50, you are 45. Both of us, we have been appointed as the judge of the Supreme Court. I was appointed 5 days later. That means you were appointed today. 5 days later, I was appointed by the president. Despite the fact that you are younger to me, I am older. But you will be the senior most judge. because you were appointed to the Supreme Court ahead of me. Which means out of all these judges who were appointed earlier, that means at the Supreme Court, what is your experience? 7 years. Even if you are 62, but your experience is 2 years, but somebody is 55, but his experience is 7 years. That individual with 7 years experience, despite lesser age, will be the senior most judge of the Supreme Court. And that was the convention. The convention was that the senior most judge of the Supreme Court was appointed as the Chief Justice of India. That means whenever there is a vacancy in the office of the Chief Justice of India, the president will look at who is now the senior most judge of the Supreme Court. That person was appointed as the Chief Justice of India. And when other judges were to be appointed, for example, there is vacancy here as well, Chief Justice was always consulted. Can you please recommend who do you think is best fit for this post? These are our suggestions. These are your suggestions. Let's discuss. Okay, this person is good. Can we appoint him? Okay, thank you so much. Please have a cup of tea with me. After that, you can go back to the Supreme Court. That is how, through consultations, the judges were appointed. But we reached conflict. In this time, Prime Minister is Srimati Indira Gandhi. 24th April 1973. Keshavananda Bharati versus State of Kerala. Supreme Court innovated a doctrine known as the doctrine of basic structure. Yes, Parliament has the power to amend any provision of the Constitution, but subject to basic structure. And now a 13-judge bench of the Supreme Court has imposed limitations on the amending powers of the Parliament. 24th April 1973, Justice Sikri, the Chief Justice of India, retires. And now we had to find his successor. What is the convention? Senior most judge of the Supreme Court shall be appointed as the Chief Justice of India. But instead, what the president did? President appointed Justice A.N. Ray as the Chief Justice of India, superseding 3 other judges. That means in the list of the seniority, there were 3 other candidates who were senior to Justice A.N. Ray. In terms of seniority, Justice A.N. Ray was at serial number 4. All the 3 judges were overlooked. Justice A.N. Ray was appointed as the Chief Justice of India by the president, which basically means the Prime Minister recommended to the President Justice A.N. Ray should be appointed as the Chief Justice of India. What did these 3 other judges do? They resigned. And why was Justice A.N. Ray handpicked? We come to know very soon. Justice A.N. Ray immediately, once he assumed office, set up a bench to review the Keshavananda Bharati case. 24th April 1973, Keshavananda Bharati judgment is given, delivered. Chief Justice Sikri retires. Now a successor has been appointed by the president, this time violating the convention. Instead of the senior most judge, a judge who was at serial number 4 in terms of seniority was appointed as the Chief Justice of India. And he is now reciprocating by setting up a bench to review Keshavananda Bharati judgment. Somebody dialed Nani Palkhiwala, who was the lead lawyer in Keshavananda Bharati case. Sir, do you know what has happened? He said, I know Justice A.N. Ray has been appointed. No, that's not it. He has opened the review of Keshavananda Bharati. He said, how can he do that? And he quickly rushed to the Supreme Court. For the next 2 days, Nani Palkhiwala is thundering before the court. And he's trying to convince the Supreme Court why you should not review this judgment or why you should not overlook this judgment. Why you should not override this judgment. Why should you not give a judgment which is contrary to the Keshavananda Bharati spirit? But at the end, he asked a simple question. There was Justice A.N. Ray, There were 13 other judges. A simple question was asked by Nani Palkhiwala at the end of 2 days. Who filed this review? Who asked you to review this judgment? 100% it is clear. If the judgment is given by the Supreme Court itself can review that judgment. That is something that we will discuss today or tomorrow, known as the review petition. So if the judgment is given by the court, you can file a petition asking the court to please review this judgment. That's called review petition. But somebody has to approach the court to file this review petition. Justice A.N. Ray was asked, who filed this review petition? And then people realize that nobody had asked for a review. Justice A.N. Ray said, we have the state of Maharashtra, which has asked for review, and various other states. The Advocate General of the state of Maharashtra was also present. He got up. He said, we did not file this review. And ultimately, all the other judges who were also confused now, who were surprised that they are now on a bench to review Keshavananda Bharati judgment, wherein no person has asked for the review. And after 2 days, this bench was dissolved. Keshavananda Bharati judgment stayed. But what also stayed? A stain on the character of Justice A.N. Ray. 2 years later, emergency was imposed in June 1975. And during this emergency period, a law was also passed known as MISA, Maintenance of Internal Security Act. Under this law, if an individual has been arrested, this individual cannot approach the Supreme Court. That means there will be no such thing as habeas corpus. And under this law, journalists, activists, student leaders, trade union leaders, opposition leaders, for example, if you go through the archives of Indian Express, the next day when emergency was imposed, the headline would said, Vajpayee, Advani, Ashok Mehta, JP arrested, emergency imposed. The matter before the court was ADM Jabalpur versus Shivakant Shukla, 1976. This is also known as the habeas corpus case. The question before the court was, is habeas corpus suspended during emergency? What is the constitutional validity of this law, which says if you are arrested under this law, you cannot file a habeas corpus, or somebody cannot file a habeas corpus on behalf of you in the Supreme Court of India? There were 5 judges who had to decide this matter. 5 judges. 4 judges said, yes, this habeas corpus is suspended during emergency. One such judge was the father of the current Chief Justice of India, Justice Chandrachud. And the only judge who dissented was Justice Khanna. And then beautiful articles were written, particularly in the foreign press, because in India, press was not free during the emergency. Whatever a media house, a newspaper had to publish, first it went to the government. Once the government okayed it, then it could be published. That is what we call censorship. Beautiful articles were written in praise of Justice Khanna, that here is this man who stood up to a dictator. That's what they called, not my words. And 4 judges said habeas corpus is suspended during emergency. And this case came to be known as the black spot on India's judiciary. And a couple of years ago, this judgment has been overturned. Supreme Court has said this reasoning, this logic of the Supreme Court in 1976 was wrong. And in legal language, we called it per incuriam. That means this judgment was given in ignorance of the law. But that's besides the point. Justice Khanna was the senior most judge of the Supreme Court. And he was next in line to be appointed as the Chief Justice of India, because we were following a convention. And the convention was a senior most judge of the Supreme Court should be appointed as the Chief Justice of India. Justice Khanna has now stood up to the government, said you can't suspend habeas corpus during emergency. And ultimately, what happened? Justice Khanna was overlooked. Justice Beg was appointed as the Chief Justice of India. And Justice Khanna did the same thing as three of the other judges did in the 1973. He resigned in protest. And now we are entering into this phase of conflict. And this conflict was not only at the Supreme Court, this was at the High Court level as well. I am a politician belonging to the ruling party. My case is before a High Court judge. I'm trying to bribe him, give this verdict in favor of me. The judge is adamant, the judge is upright, he does not listen to me. What I will do, I will ask the ruling party at the center, can you please transfer that judge? That judge of the Allahabad High Court was shifted to Manipur High Court. That judge from the Calcutta High Court was shifted to Madras High Court. That means transferring of the judges from one high court to another high court. This was also done to ensure that justice is delayed, justice is denied. Matter went to the court, known as the first judge's case, SP Gupta versus Union of India. In this case, two things were to be decided by the court. Number one, can the judge of a high court be transferred against his will? Number two, what is the meaning of this term consultation? Is it same as concurrence? SP Gupta versus Union of India, 1981-82, known as the first judge's case, Supreme Court said a judge of a high court can be transferred from one high court to another high court, even against his will, by the President of India. And when the President appoints Chief Justice, when the President appoints other judges, Chief Justice should always be consulted. That is something mentioned in the Constitution. But this consultation is not concurrence. What is the difference between consultation and concurrence? I am asking you, can I take a class on Sunday? Because we are running short of time, we have few topics to complete. Can I take a class, an additional class on Sunday from 6 a.m. till 11 a.m.? I'm consulting you. If majority of the students say, no, please don't take the class, or don't you dare take the class, I'll say it doesn't matter. The class starts 6 o'clock in the morning on Sunday. We will continue this class till 12 o'clock. I'm only consulting you. That doesn't mean whatever you tell me, that is going to be binding on me. I'm consulting you because maybe you would say, sir, on Sunday we have an exam. On Sunday, majority of the people would be busy in a state civil services examination. Then I would accept this. You have a sound reason to say that we should not have a class on Sunday. I agree. If there is no reason, I'll say it doesn't matter. We will still have a class. So it's not concurrence. It's consultation. If it was concurrence, I'm asking you, can I take a class on Sunday? You said, no, you can't take a class. I can't take this class. Because whatever you are telling me is now binding on me. When the Constitution says, when other judges of the Supreme Court are to be appointed, judges other than the Chief Justice of India, Chief Justice of India shall always be consulted. What is this consultation? Is this concurrence or only mere consultation? Supreme Court said consultation is not concurrence. That means ultimately it is the job of the executive. It is under the domain of the executive to appoint judges to Supreme Court and High Court. This was the first judge's case. Then less than a decade later, Sakara versus Union of India, known as the second judge's case. Sakara stands for Supreme Court Advocates on Records Association versus Union of India. And this time, the lead lawyer is Fali S. Nariman. who was one of the very close lieutenants of Nani Palkiwala. Nani Palkiwala had groomed Falias Nariman, and now Falias Nariman is approaching before the court, challenging the role of the executive in judicial appointments, saying executive should not have any role. In this judgment, second judge's case, 1993, Supreme Court said, number one, appointment of judges it is an integrative, participatory, consultative process to select best possible talent to the judiciary. Supreme Court said this process of appointing judges to Supreme Court and High Court, it's an integrative, consultative, participatory process. Participatory process between executive and judiciary. Because we have to select best possible talent to judiciary. Executive, you would not know who to appoint because you have not worked with the judges. We are in judiciary. We know who are these lawyers who come before us. And if you are an advocate for 10 or more years, you are now qualified to be appointed as a judge. These lawyers come before us for their cases. We interact with them. We rule in favor of them or against them. That's how we get to know whether they are worthy of this office or not. And then we will give you advice, we will give you suggestion, and these individuals should be appointed. Because what is the objective? To select the best possible talent in the judiciary. We know these lawyers in and out. And that is why, my dear, this consultation which is mentioned in the Constitution, this consultation is concurrence. That means whatever is communicated to you by the Chief Justice of India is binding on the President of India. That is what Constitution mentions. While appointing judges other than the Chief Justice of India, the Chief Justice of India shall always be consulted. This phrase shall always means it is concurrence. That means whatever advice is given by Chief Justice of India to the President, that is binding on the President. And when we say Chief Justice of India, who are we? We are the Supreme Court. Who is the Supreme Court? Final interpreter of the Constitution. If the Constitution says consult Chief Justice of India, you don't have to only consult Chief Justice of India. Then you have to consult plurality of judges. Plurality of judges means consult Chief Justice of India plus 2 senior judges of the Supreme Court. So whenever there is a vacancy, whether it is in the High Court or it is in the Supreme Court, President will consult not the Chief Justice of India as an individual, Chief Justice of India as an institution. Because we are the final interpreters of the Constitution. When the Constitution says the President shall always consult Chief Justice of India, it did not mention, it did not specify, it did not mean Chief Justice of India as an individual. It means Chief Justice of India as an institution. So you have to consult plurality of judges. Chief Justice of India and 2 senior judges of the Supreme Court. And this is what led to the emergence of collegium system. This is collegium. Chief Justice and 2 senior judges of the Supreme Court. Consult them. And whatever advice they give, that is binding on the President of India. Which means if there is a discussion on my name, whether I could be appointed I should be appointed to the Supreme Court as the judge or not. If the president is in favor of me, if one judge is also in favor of me, but Chief Justice and the other judge says no, that means by majority, this collegium says no, this person cannot be appointed. I cannot be appointed. And if this collegium recommends your name, it is binding on the President of India. President will have to appoint that individual as the judge of the Supreme Court or High Court. That means from the earlier position where executive had the complete control in appointing judges, now slowly and steadily, Supreme Court has snatched this power from the executive and given this power to itself. Supreme Court said, listen, President, senior most judge of the Supreme Court shall be appointed as the Chief Justice of India. But that's something that we were doing always. No, previously it was the convention. We thought you will always act in good faith. That is why it was a convention. It was not mentioned anywhere. Now we will mention it in the judgment. The senior most judge of the Supreme Court shall be appointed by the president as the Chief Justice of India. I said, okay. This was in 1993. And this caused a lot of concern amongst the executive, amongst the members of the legislature as well, saying how can Supreme Court arrogate the power of appointment to itself? This goes against separation of powers. Because Dr. Ambedkar had said, we need independence of judiciary, but at the same time, we cannot say that appointment of judges will be done by judges themselves. It looks like India is now becoming the only country of the world where judges are appointed by themselves, which means judges recommend names to the president, which is the executive, and it is binding on the president to accept those names. So in India, judges are appointed by themselves. This is where the year was 1998. Justice Verma was the Chief Justice of India, and the government advised the president, can you use Article 143? So what is Article 143? Under Article 143, any matter can be sent to the Supreme Court by the president, asking the opinion of the Supreme Court on that matter. And that is what is known as presidential reference. And such cases are always prefixed with RE, Ray Appointment of Judges 1998. This is presidential reference. That means now because of this entire controversy, now this matter is referred to the Supreme Court by the president. Dear Supreme Court, can you please give me an opinion on how judges are to be appointed? Because your 1981 case and your 1993 case conflicts with each other. Tell us, what do you think? How the judges should be appointed? Give me an opinion on that. This is my presidential reference. That means president is referring a matter to the Supreme Court, asking the opinion of the Supreme Court on this matter. Supreme Court said, don't worry. We are here to give you an advice. And we are here to give the advice. And the first advice is appointment of judges is an integrated, participatory, consultative exercise to select the best possible talent to the judiciary. Said, we know this. You said this in 1993 as well. Come to the point. How the judges are to be appointed. Okay, you seem to be running out of time. First, I will tell you how the Chief Justice of India is to be appointed. Outgoing Chief Justice of India will nominate his successor, who is fit to hold the office. President will have to appoint Chief Justice of India first. First, we will discuss how Chief Justice is to be appointed. Previously, we know what you did. Remember A.N. Ray? Remember Justice Beg? Said, let's not get along that path. Okay, that's why I'm saying outgoing Chief Justice will nominate his successor and you have to appoint that individual. So, what does that mean? That means if Justice Deepak Misra is the Chief Justice of India, before his retirement, he will nominate his successor. And who is the successor going to be? Senior most judge. That means after Deepak Misra, who is the senior most judge of the Supreme Court? The outgoing Chief Justice will nominate his successor, and that successor, President will have to appoint. Justice Deepak Misra, before his retirement, nominated Justice Ranjan Gogoi as the Chief Justice of India. Justice Ranjan Gogoi was appointed as the Chief Justice of India. Justice Ranjan Gogoi, before his retirement, nominated his successor, the senior most judge of the Supreme Court. That person was appointed as the Chief Justice of India. S.A. Bobde, the Chief Justice of India, nominated his successor, who is the senior most judge of the Supreme Court, Justice Ramana. Justice Ramana is now the Chief Justice of India. Justice Ramana, before his retirement, nominated his successor, Justice U.U. Lalit. Justice U.U. Lalit is the Chief Justice of India. Justice U.U. Lalit, the outgoing Chief Justice, before his retirement, nominated his successor. Who is the successor? Senior most judge of the Supreme Court, Justice Chandrachud, appointed as the Chief Justice of India. That means when you have to appoint the Chief Justice, now executive will have no role. You just have to issue the formal order saying now this person is the Chief Justice of India. Because the outgoing Chief Justice will nominate his successor. And who is the successor going to be? The senior most judge of the Supreme Court who is fit to hold the office. Now this is where there is confusion. Can the outgoing Chief Justice recommend his successor who is not the senior most judge of the Supreme Court? Can he nominate someone else? He can, if this senior most judge of the Supreme Court is not fit to hold the office. But this controversy has not resulted as of now. We don't know what will happen tomorrow if the outgoing Chief Justice will nominate not the senior most judge of the Supreme Court, but someone else, saying this senior most judge of the Supreme Court is not fit to hold the office. Or can we say that the outgoing Chief Justice has nominated the senior most judge of the Supreme Court, but the President rejects it, saying, no, this person is not fit to hold the office? Who will decide who is not fit to hold the office? That's something that we don't know. Whether it is the executive which can say this or whether it is the judiciary we can say this. But the way it is looking, it is ultimately the job of the judiciary to decide. That means the outgoing Chief Justice of India, if he considers that the senior most judge of the Supreme Court is not fit to hold the office, instead of him or her, someone else can be appointed. The next person can be appointed as the Chief Justice of India. We are now clear. The outgoing Chief Justice will nominate his successor to the President, which is binding on the President, and the successor has to be the senior most judge of the Supreme Court who is fit to hold the office. Sir, okay. Now you got the clarity how Chief Justice is to be appointed? Yes, sir. Now where are you going? Come here. I now tell you how the judge of a Supreme Court is to be appointed. How? Consult Chief Justice of India plus 4 senior judges of the Supreme Court. But my lord, in 1993, you said Chief Justice of India and 2 senior judges of the Supreme Court. So that was in 1993. Now it is here 1998. Because what is the appointment of judiciary? It's an integrated, participatory, consultative exercise to select the best possible talent to the judiciary. If you are consulting Chief Justice of India, you're not consulting Chief Justice of India as an individual. You are consulting Chief Justice of India as an institution. And for that, you have to consult plurality of judges. And you have to consult Chief Justice of India and 4 senior judges of the Supreme Court. Okay, sir, where are you going? Listen, I have a lot of story to tell you. Any name not acceptable to Chief Justice of India cannot be sent to the President. And if more than one judge they do not agree on a name, this name cannot be sent to the President for appointment. Which means who will appoint the judges of the Supreme Court and High Court? President of India. But after consultation with now collegium. Because previously, Constitution said while appointing judges to the Supreme Court or High Court, the President shall consult such of the judges of the Supreme Court and High Court as the President may deem necessary. Supreme Court says the interpretation is you have to consult the collegium. Collegium consists of Chief Justice of India and 4 senior judges of the Supreme Court. Now, what if there is a difference of opinion? For example, the collegium is deciding and discussing my name. Can Sarmad be appointed as the judge of the Supreme Court? Can we recommend his name to the President? Chief Justice of India and 2 other judges, they agree with me. They agree on my name. But 2 other judges say, no, we don't agree. He's not a fit candidate. He's not a good candidate for the post of the judge. That means more than one judge has disagreed with my name. No matter who this judge is, whether it is Chief Justice of India, whether it is other judge, but since more than one judge has disagreed with my name cannot be sent to the President for appointment. Ideally, there should be consensus on my name. My name should be recommended. And this should be done by the consensus. All the judges of the collegium should agree. If not, then we have to go by the majority. If more than one judge, which means if 2 or more judges, they don't agree with my name cannot be sent to the President. Also, if all the 4 judges say yes, Sarmad is a good candidate, let's recommend him to the President for appointment as the judge of the Supreme Court. But Chief Justice of India says, no, I don't agree. Despite the fact that 4 judges are saying yes, but Chief Justice is saying no, my name cannot be sent to President for appointment, which means in judicial appointments, Chief Justice of India enjoys a veto. Any name which is not acceptable to Chief Justice of India, even if 4 other judges agree, cannot be sent to President for appointment. The Government Attorney General said, okay, my lord, I think we will take your leave. We have understood the process. I said, where are you going? I have something more to discuss. I said, what? How is the judge of a high court to be appointed? Yes, please tell me. But before I tell you, see, previously we had a problem. Sir, what? The problem was there used to be vacancies in high courts. 20% vacancy, 30% vacancy, 50% vacancy. There used to be vacancy in our Supreme Court as well. But you would delay the process of appointment because you had to initiate this process of filling the vacancy. Because if there are 10 vacancies in Allahabad High Court, the President had to start this process saying there are 10 vacancies in Allahabad High Court. Now I will consult the Chief Justice of India. I will consult other judges, and then we will agree with these 10 names, and then these 10 names will be appointed. So this process was complicated, and it led to a lot of vacancy. Now, if the vacancy is in the Supreme Court, if the vacancy is in the High Court, Chief Justice of India will initiate the appointment process. And if there is a vacancy in a high court, the Chief Justice of High Court will initiate the process of appointment. Sir, what are you saying? I'm saying if there are 10 vacancies in Allahabad High Court, the Chief Justice of Allahabad High Court will initiate this process, telling us that there are vacancies, 10 vacancies in Allahabad High Court. Previously, the president would initiate this process, the executive would initiate this process. Same goes with the Supreme Court as well. I, as the Chief Justice of India, will initiate the process of filling this vacancy. That means we will set up, the collegium is there, we will meet, we will discuss names, and ultimately we will only recommend you the names. Whatever names we recommend, that's binding on you. I said, okay, you are the final interpreter of the Constitution. You know it better. But tell me how the judge of a high court is to be appointed. For that, you consult Chief Justice of India and 2 senior judges of the Supreme Court. There is a process that is followed. And what is that process? For example, there is a vacancy in Calcutta High Court. The Chief Justice of that High Court will meet senior judges of the Calcutta High Court. That means they have a collegium there as well. And they will discuss few names. Who is the good lawyer here? Can we promote somebody from the subordinate judiciary, from the district courts, and appoint them as the chief judges of the High Court? Once they have a clarity on these names, that these are the names that we agree should be appointed, then they will send a copy of these names to the governor as well, to the chief minister as well, and to the Chief Justice of India as well. Now, at this Supreme Court level, all these names will be decided and discussed by Chief Justice of India and 2 senior judges of the Supreme Court. And then they will advise the president whether these persons should be appointed or not. That means in order to appoint judge of a high court, the president shall consult Chief Justice of India and 2 senior judges of the Supreme Court. But before that, the process had already initiated at the High Court level, where the Chief Justice of that High Court is consulting his senior colleagues, discussing various names, and then these names are sent to governor as well, chief minister as well, and Supreme Court collegium as well. Why? To seek intelligence report, to seek any other report, which we may not know. For example, I can tell you this lawyer is very good, he argues cases better, but I don't know more details about this person. Government would know all the details, or government will find out if there is something bad about this individual. And that happens in all appointments. For example, tomorrow when you will be appointed, when you will clear the civil services examination, there will be a background check. Have you been arrested before? Is there any case pending against you? Are you involved in unlawful activities? Are there some criminal cases pending against you? All these background checks will be done. And then once that background check is clear, then you will be appointed. Similarly, the judges would know that this lawyer is good, but judges would have no idea about the background of this individual. For the background check, this matter will be sent to the government. Government will use its agencies to conduct an investigation, to conduct some sort of a survey on this individual. Said, okay, sir, we understood. But Attorney General, where are you going? Come, I'll tell you something else. Sir, what is there left to say now? If you have to transfer a judge, for that consult Chief Justice of India plus 4 senior judges of the Supreme Court plus 2 Chief Justices of the High Courts. Sending state and the receiving state. We are here to discuss how the judges are to be appointed. For that, Mr. President, you needed our advice because you have referred this matter to us, asking our views on this matter. We are giving you a reference on this, presidential reference. First, the appointment process is an integrated, participatory, consultative exercise to select the best possible talent to the judiciary. For that, if you have to appoint the Chief Justice of India, the outgoing Chief Justice shall nominate his successor, who is the senior most judge of the Supreme Court, fit to hold the office. If you have to appoint judge to a Supreme Court, for that you have to consult Chief Justice of India and 4 senior judges of the Supreme Court. If you have to appoint judge to a High Court, for that you have to consult Chief Justice of India and 2 senior judges of the Supreme Court. If you have to transfer a judge from one High Court to another High Court, for that you have to consult Chief Justice of India, 4 senior judges of the Supreme Court and 2 Chief Justices concerned. If a judge is to be transferred from Calcutta High Court to Madras High Court, you have to consult Chief Justices of those 2 High Courts as well, sending state, receiving state. That is how the judges are to be appointed. Attorney General said, "Sir, whatever your recommendation is it binding on the President?" The Supreme Court said, yes, it is binding on the President. But can we please not make it binding? Why? Because if you recommend a name, we may have objections to that name. We will raise those objections. That person should not be appointed. Don't we have a say? I said, yes, you're right, but whatever objections you have, give it in writing. Any objections that you will have, give it to us in writing. Then we will look at your objections again and then take a call. If we reiterate the name, if we say, no, this person has to be appointed, you have no other option but to appoint that individual. But if we agree with your objections, we will drop that name. We will ask you, no, don't appoint this individual. I said, okay. And this is how the judges are to be appointed. There was a lot of criticism of this collegium system. On one hand, there were judges who praised it. There were experts who praised this, saying now for the first time, we have executive removed from the appointment process. Because look what Madam Gandhi did to the judiciary in the 1970s. They were asked to crawl and they bent instead. The judges were transferred from one high court to another high court by the executive. So the ruling party will have certain cases against them in the high courts. If the judge is not acceptable to them, they will transfer this judge. Now it cannot happen because they have to seek the permission of the collegium. Justice Beg can supersede other judges. Justice A.N. Ray can supersede other judges. And then Justice A.N. Ray would set up a bench to review Keshavaranda Bharti. This will not happen. Indira Gandhi was asked, what is your take on this matter? She said, I need committed judiciary. And what is this committed judiciary? She said, judiciary should be committed to the ideology of the political party in power. What is that ideology? She wanted land reforms. She wanted socialist measures to be taken, banks to be nationalized, privy purses to be abolished. Judges said no. Indira Gandhi said, judges should be committed to the ideology of the political party because you have to work together. And we have to work together to let the nation prosper. We cannot prosper as a nation if we have one set of ideology and the judges have a different set of ideology. We are socialist and the judges are capitalists. That should not happen. So we need committed judiciary. Committed judiciary is an assault on the independence of judiciary. Judiciary should not be committed. It should be independent. And those who favored the introduction of the collegium system said, now finally we will come out of this committed judiciary. Instead, we will ensure independence of judiciary. That means the judges will, without any fear or favor, give their verdicts. Because their appointment is not based on the government. So they will not be amenable to the pressures of the government. But others criticized. Criticized on the ground that this collegium system violates the constitution. Where is it mentioned that the president shall appoint Chief Justice of India after consulting the collegium. Appoint other judges after consulting the collegium. This term collegium is not mentioned anywhere in the constitution. So it violates constitution. And my lord, please tell me, what are you discussing in these collegium meetings? What is the criteria that you follow to recommend this person? Why is it that a lot of these judges of the Supreme Court as well as High Court, they have some connection to bureaucracy, to politics, to judiciary as well? With no offense to the current Chief Justice, his father was also the Chief Justice of India. So we talk about nepotism. Is there nepotism in judiciary as well? Where the Supreme Court and the senior judges, they act as some sort of a club and recommend their family members, their known members to the High Courts and the Supreme Court. What exactly do they discuss in these collegium meetings? We don't know. And on top of that, Supreme Court tells government you have to be transparent. Tell us how you took this decision. But if the government is asking the Supreme Court, you tell us why did you recommend this person, you don't have an answer. Because this entire process lacks transparency. When there is no transparency, there is no accountability either. And Supreme Court, you said previously there used to be a lot of vacancies and these vacancies were not filled by the government. Now we will initiate the process. I, as the Chief Justice of India in the Supreme Court, I, as the Chief Justice of a High Court in a High Court. Despite collegium system, my lord, there are 45% vacancies in different high courts in India. But perhaps the most damning, scathing criticism of collegium system came from two judges of the Supreme Court itself. In Suraj India Trust 2010 case, some questions were asked by two judges of the Supreme Court to the Chief Justice of India. And we are in 2023. These questions have not been answered yet. What are the questions? Question number one. Will the two decisions of the court in 1993 and 1998 really amount to amending Article 124, Clause 2 of the Constitution? Because Article 124, Clause 2 said, every judge of the Supreme Court shall be appointed by the President after consulting with such of the judges of the Supreme Court and High Court as he may deem necessary. And while appointing judges other than the Chief Justice of India, the Chief Justice shall always be consulted. Now, because of 1993 and 1998 judgments, you are saying the President will appoint a judge after consulting collegium. Is this not amendment to the Constitution? Dear Chief Justice of India, please answer. Is there any collegium system mentioned in the Constitution? Please answer. Is this term collegium mentioned anywhere? Or not just term, is the concept collegium found anywhere? And how can you say Chief Justice of India is not an individual? Chief Justice of India is an institution, consult plurality of judges, 2 judges, 4 judges. Please answer. Please answer. Can the Constitution of India be amended only by Article 368? Or can the Constitution be amended by judicial verdict? Because you seem to have amended the Constitution through your judgments by introducing collegium system and saying this recommendation is binding on the President. In the constitutional scheme, can judges be appointed by discussions and consensus between judiciary and executive, or can judiciary alone make the appointments? Dear Supreme Court, Chief Justice, you have said in your judgments, separation of powers is part of the basic structure. One form of separation of power is checks and balance. One way in which you can impose checks on the judiciary is through appointment and removal. Appointment is done by executive. Removal is done by executive based on the resolution passed by the legislature. But today, judges are appointed by themselves. Is it not violative of the doctrine of checks and balances? Does the word consultation in Article 224 mean concurrence? Sir, 124. No, 224 deals with appointment of High Court judges. There also, Constitution said Chief Justice of India shall be consulted. Is this term consultation same as concurrence? Dear Supreme Court Chief Justice, please answer. But perhaps the even more scathing criticism is this point. Dear Chief Justice, can words in the Constitution be made redundant as if they have no value? No value in the sense? Listen to me carefully. The President shall appoint judges to the Supreme Court and High Court after consultation with such of the judges of the Supreme Court and High Court as he may deem necessary. Some words have been made redundant now. Redundant in the sense, President originally had to consult Supreme Court judges as well as High Court judges. Now this judgment is saying consult Chief Justice of India and 4 senior judges of the Supreme Court. To appoint a High Court judge, you need to consult Chief Justice and 2 senior judges of the Supreme Court, which means there is no need for the President to consult a High Court judge. Or should we say, President cannot consult a High Court judge because we will not allow it, says judiciary. But Constitution says you can consult such of the judges of the Supreme Court and High Court as you may deem necessary. Not just this. Original Constitution said, President, while appointing the judge to a High Court, the governor of that High Court shall be consulted. Governor shall be consulted. In this entire collegium system, where is the role of governor? Nothing. Absolutely zilch. Then can judiciary, through its order, make some of the words mentioned in the Constitution redundant? You have made some words redundant. There is no role of a High Court judge. Redundant. There is no role of a governor. Redundant. On top of that, you are saying the President shall consult Chief Justice and 2 senior judges. Chief Justice and 4 senior judges. Why only senior judges? Why not junior judges? What if President wanted to consult a junior judge whom she thinks that he is talented or she is much talented, can give me a better advice? Why are you insisting only on the senior judges? Why not junior judges? There should be liberty to consult junior judges as well. Is there any convention that President is bound by the advice of Chief Justice of India to prevail over the clear language of Article 124? Article 124's language is clear. While appointing judge to a Supreme Court or High Court, the President shall consult such of the judges of the Supreme Court and High Court as the President may deem necessary. And now you're saying, no, you have to consult. And on top of that, that consultation is concurrence. On top of that, that is binding. We thought that Constitution says there shall be Council of Ministers with Prime Minister at its head to aid and advise the President who shall act on that advice. Now we are saying there shall be Chief Justice of India who will advise the President and it is binding on the President. Give us these answers. And finally, should the 2 decisions be overruled by a larger bench? Can we set up a larger bench with higher strength than the judges who took this decision in 1993-1998? We are in 2023. These questions have not been answered. But perhaps answered indirectly. Indirectly how? This was a public interest litigation filed by Suraj India Trust in 2010, in response to which 2 judges of the Supreme Court are asking questions to the Chief Justice of India. All these questions are unanswered, but perhaps answered indirectly. How? A couple of years ago, Supreme Court banned Suraj India Trust from filing further public interest litigations. Maybe not connected to this case, or may be connected to this case, I don't know. But Suraj India Trust cannot file a public interest litigation now. A lot of criticism was going on. Mr. Modi came to power, had consultation with the opposition. Everybody seemed to be worried because judiciary has now taken it upon itself to appoint judges. Judiciary can do anything now. We thought we mentioned D. Lolme's statement for British Parliament. British Parliament can do anything except convert a man into a woman and a woman into a man. But for our Supreme Court, we can say Indian Supreme Court can do anything, even converting a man into a woman or a woman into a man. The year was 2014. Parliament got together, amended the constitution, and created a constitutional body called NJAC, National Judicial Appointments Commission. What was the role of this NJAC? Collegium system should disappear. Whatever is the role of the collegium will be given to NJAC. What is the role of collegium? To recommend the judges to the Supreme Court, to recommend judges to the High Court, to recommend transfer of judges from one High Court to another High Court. Now, these functions will not be performed by collegium because collegium would disappear. Instead, these functions will be performed by this constitutional body known as NJAC. What will be the composition of NJAC? It will have Chief Justice of India as the chairperson. It will have 2 senior judges of the Supreme Court as members. It will have a law minister as part of it as well. And it will have 2 eminent persons. 2 eminent persons. And these 2 eminent persons will not be appointed by the government, will be appointed by a committee which will consist of Chief Justice of India, Prime Minister, and leader of the opposition in Lok Sabha. If there is no leader of opposition in Lok Sabha, then the leader of the single largest party in Lok Sabha. So, leader of opposition, Chief Justice, Prime Minister, they will sit together and come up with 2 names, 2 people, 2 eminent persons. And these 2 eminent persons will be part of NJAC. And what will NJAC do? NJAC will take over the role of the collegium. Many people praise this functioning, saying at least now there is some sort of consensus. Consensus in the sense, this NJAC seems to be a better body than collegium because NJAC will have members from judiciary, will have member from executive, will have member from civil society as well, 2 eminent persons. So this is the best combo that we can have. Further, if 2 or more members do not agree, no recommendation can be sent to President. That means who will appoint judge? President. Who will appoint Chief Justice? President. Who will appoint judge to a High Court or the Chief Justice of a High Court? President. But now after consulting with NJAC, NJAC will meet Chief Justice, 2 senior judges, Law Minister, 2 eminent persons. If 2 or more do not agree with a name, that name cannot be sent to President for appointment. So as much as possible, there should be consensus in the meetings of NJAC. NJAC was passed, 99th Constitutional Amendment Act, 2014. And to tell you, this NJAC bill was passed by both houses of the Indian Parliament by special majority, and then before it was sent to President for signature, it was sent to all the state legislatures in India. Only when at least half of the states agreed, then NJAC bill was sent to President for signature. President signed this bill, NJAC became a law, it became an act. Because such a bill affects the federal principles. And I told you any bill which tries to amend these federal features, such as the powers and functions of judiciary, Supreme Court and High Court, that requires constitutional amendment, that requires ratification by at least half of the states. If you want to increase the number of judges, that's not a constitutional amendment. But if you want to change the structure of the Supreme Court and High Court, if you want to change the appointment process of the Supreme Court and High Court, for that you have to amend the constitution and get ratification of more than half of the states, at least half of the states. But even after it was ratified, this NJAC was challenged before the court. And now we have the same lawyer who challenged the judicial process, who challenged the appointment process in 1993, in 1998, now in 2015, Fali S. Nariman. And in 2015, 5-judge bench of the Supreme Court, by the majority of 4:1, struck down NJAC, saying NJAC is unconstitutional. Only one judge dissented, Justice Chalameshwar. Saying collegium system, I am also a beneficiary of collegium system. Because of collegium system, I am the judge of the Supreme Court. But I don't agree with this collegium system. You have completely removed the role of the executive, which is against constitution. This entire process is opaque, lacks transparency. This is not a good process to follow. I don't agree that NJAC is unconstitutional. Perhaps NJAC is constitutional. This is much better body than collegium to appoint judges. But 4 other judges by the majority said NJAC is unconstitutional. NJAC was declared unconstitutional. That means collegium system continued. Why NJAC was declared unconstitutional? Supreme Court said, number 1, independence of judiciary is part of the basic structure. Judiciary should be independent. It should not come under the influence of the executive. Because we know what happened in the 1970s. We despise this person, the law minister. He should not be there. Since he is here, it is unconstitutional. Because it is interference of executive in judiciary, which violates independence of judiciary, which is part of the basic structure of the constitution. But maybe, Supreme Court thought if we only say independence of judiciary is part of the basic structure, people would find it difficult to accept how this NJAC violates independence of judiciary. We have to come up with some other solid reason why NJAC is unconstitutional. And 4 judges said, primacy of Chief Justice of India in judicial appointments is also part of the basic structure. Primacy of Chief Justice of India. Once NJAC sits, what if there is a discussion on my name? Can Sarmat be recommended to the president by NJAC for appointment? 2 senior judges said yes, he's a good candidate. Law minister says brilliant candidate. 2 eminent person says eminent candidate. Chief Justice says no, cannot be sent. I don't like him. I don't like his hairstyle. But his opinion would not matter. Because if 2 or more members say no, this person should not be sent to president for appointment, then my name will not be sent. Previously, what was the position? Chief Justice of India had the virtual veto in appointment. Any name not acceptable to Chief Justice of India cannot be sent to president for appointment. 4 judges of the Supreme Court said, look what NJAC is doing. It has snatched this veto of the Chief Justice of India. This veto, and now a beautiful word is given to it, primacy of Chief Justice. Say veto of Chief Justice. Why hide under this euphemism of primacy of Chief Justice of India in judicial appointments? Say it. Veto of Chief Justice of India in judicial appointments is also part of the basic structure. Since NJAC does not give Chief Justice a veto, it is unconstitutional. It's against the basic structure because it violates another basic structure which we have just invented, which is primacy of Chief Justice, basically veto of Chief Justice in judicial appointments. But be that as it may, NJAC is unconstitutional. Collegium system revives and collegium system continues. But was NJAC really against the independence of judiciary? For that, we have to look at the Constituent Assembly debates. For that, we have to look at other provisions of the Constitution. Dr. Ambedkar said the most important office under the government is that of CAG. But next is the judge. And we have to ensure that this judge is able to give judgments without fear, without favor, without threat, without coercion. For that, we need judiciary to be independent. But independent judiciary does not mean that judiciary can appoint its own members. Judiciary should be allowed to remove its own members. No. We will give you independence, but in a different form. And what is that independence? Judges of the Supreme Court and High Court, they do not hold office during the pleasure of the president. That means they have a secure tenure. It's not like Attorney General. It's not like the Chief Minister or the ministers. It's not like a civil servant where you hold office during the pleasure of the president. Tomorrow, once you're appointed, you will hold office during the pleasure of the president. But the judges of the Supreme Court and High Court, they do not hold office during the pleasure of the president. They have a secure tenure. Not just secure tenure, their salaries, allowances, pensions as well is charged on the Consolidated Fund of India. That means such expenditures can only be discussed but cannot be voted upon when budget is passed. That is how Constitution gave you independence. That you will not be holding office during the pleasure of the president. That your salaries, allowances will be charged on the Consolidated Fund of India, not subject to the vote of the Lok Sabha. And whenever you give any verdict on your judgments, there can be no discussion in the parliament or the state legislature. Parliament can discuss anything. Parliamentarians can say anything. Can say anything, even if it goes against the sovereignty, integrity, unity of India. But one thing they cannot do, they cannot discuss the conduct of judges, except when they have to remove a judge. Because they have the power to pass a resolution asking the president to remove a judge. Only if that resolution, only if that discussion has to happen whether the judge should be removed or not, only at that time you can discuss the conduct of judges. Otherwise you can't. Because the discussion in the parliament or the state legislature on the conduct of a judge is expressly barred. Can't do that. Otherwise, judges will come under the influence. Judges will come under the influence when they will be criticized in the parliament. They will say, what wrong have they done? So basically, you will be influencing them. Powers conferred on the High Court to punish contempt for itself. How can you ensure your independence? Supreme Court and High Court, you can punish people if they commit contempt of yours. Judges of the higher judiciary can be removed only through a complicated process of removal by the parliament. Such a complicated process that till date, no judge of the Supreme Court and High Court has ever been removed. No judge, not even a single judge, not even the nail of a judge has been removed by the parliament. It is through this process, it is through these features that Constitution sought to provide independence to judiciary. Despite these protections, Constitution did not deem it fit that the judiciary will appoint its own members. No, because that will go against the very separation of powers, which is part of the basic structure of the Constitution. But as valued as judicial independence was to the Constituent Assembly, it did not see the vesting of the ultimate power of appointing judges on the executive as an infraction of that principle, as a violation of that principle. No, independence of judiciary is essential. But that doesn't mean we will give executive appointment power that is against independence of judiciary. No. On the contrary, it is viewed as a vital cog in the checks and balances required to ensure proper separation of powers. Taken away, Supreme Court said NJAC is unconstitutional. Further, when the Supreme Court said NJAC is unconstitutional, that means collegium will revive itself. That means now collegium will continue. Supreme Court accepted that we need suggestions how we can transform collegium system better. For the betterment of collegium system, please give us your suggestions. How can we make it function better? Supreme Court said we will put it on our website that we are inviting suggestions on the better working of this collegium. Please give us your suggestions. Many suggestions were given in the first month. After that, Supreme Court said we have received enough suggestions. We are closing the window of submitting suggestions. Supreme Court castigates government, criticizes government or other institutions if they fail to abide by social justice. You're discriminating against Dalits, you're discriminating against OBCs, you're doing this, you're doing that. Reservation should be provided, reservation should be implemented, reservation is part of the social justice. Dear Supreme Court Collegium, of all the judges that you have currently, how many judges are SCs, STs, OBCs? And how many judges are from the upper castes? How many judges are from the minorities? There is no reservation for SCs, STs or OBCs for judges post in the Supreme Court and high courts in India. Currently, among the 33 Supreme Court judges, there is one SC judge, there is one OBC judge. Supreme Court talks about gender justice. Till date, we haven't seen a woman Chief Justice of India. Forget about woman Chief Justice of India. Till recently, we hardly had a woman judge in the Supreme Court. But further problems have arisen. What are these problems? Collegium recommends a name. This name is sent to the president, who has to accept this name, or the president will send the matter back to the collegium and mention in writing what are the objections. If these objections are not acceptable to the collegium, they will reiterate the same name, re-recommend the same name, and it is binding on the president to appoint that individual. There are people who say, despite collegium system, which the Supreme Court said is very important for the independence of judiciary, despite this, judiciary is not independent. Even without having any say in appointment process, it is executive which is powerful. How executive is powerful? Number one, Mr. Gopal Subramaniam, a terrific lawyer, top lawyer of the Supreme Court. Supreme Court would have benefited hugely if he was appointed as the judge of the Supreme Court. And he was recommended by the Supreme Court Collegium to the president that Gopal Subramaniam in 2014 should be appointed as the judge of the Supreme Court. Name was sent to the president. President did not agree, did not issue the appointment order. Why? We don't know. Perhaps why? Because Gopal Subramaniam was the amicus curiae when Amit Shah's case was taken up, where Mr. Amit Shah was accused in a fake encounter of killing Tulsiram Prajapati and Ishrat Jahan and others. Amicus curiae, friend of the court. That means the court sometimes asks a senior advocate, please assist us on this case. And that case was that fake encounter case or alleged fake encounter case. Gopal Subramaniam basically fought against Amit Shah in the court. Now Amit Shah is the Home Minister. Or then he was not the Home Minister, then he was the BJP president. The government did not agree. And Supreme Court did not insist on his name. Forget about government agreeing or not agreeing. Job of the government. But Supreme Court did not agree to reiterate that name. Because once you have suggested this name to the president, it's binding on the president. But the president can raise objections in writing. If these objections are not acceptable to collegium, collegium will reiterate the name. This name was reiterated, yet he was not appointed. So where is your dream theme? The appointment of judges is an integrative, participatory, consultative exercise to select the best possible talent to judiciary. Executive still has a veto. It says, no, you can't do anything. Second instance. This is what we call pick and choose. What is pick and choose? Candidate A, B, C, D, E. 5 vacancies in Supreme Court or High Courts. This list of 5 people is sent to the president for appointment. President looks at these 5 people and tells the government, what do we do? Out of these 5, these 3 are okay. This person not good, this person not good. Why? Because they are too independent. They will pose problems to us. These 3 can be manageable. So pick these 3 people, appoint them, and keep these 2 names pending. So now the executive is picking and choosing. From a list which was sent by the collegium, some names are appointed, some names are kept pending. Kept pending for years. No action. Something bizarre has happened or something interesting has happened. Depends upon which way you look at it. Previously, all these objections which were given by the president, basically the government to the Supreme Court, it was kept hidden by the Supreme Court. Supreme Court would not explain, would not tell, would not reveal. What are these objections? Now, for the first time, under the Chief Justiceship of Justice Chandrachud, these objections have now been revealed. Revealed, number 1, Justice Mr. Saurabh Kirpal. Saurabh Kirpal is the advocate of the Delhi High Court. He was recommended by the Supreme Court Collegium to be appointed as the judge of the Delhi High Court. His name was sent to the president. Objections were raised and these objections were sent to the collegium. Because of these reasons, we don't want Saurabh Kirpal to be appointed as a judge. Previously, the Supreme Court Collegium would keep these objections hidden, would not reveal it to the public. Now, Justice Chandrachud says, enough is enough. Justice Chandrachud published these objections on the website of the Supreme Court. And what are the objections raised by the government? That Saurabh Kirpal belongs to LGBTQ community and his partner is a Swiss national, which will compromise our national security. Foreign national is the partner of Saurabh Kirpal. Supreme Court reiterated his name, saying you have raised these objections in writing. We are now reiterating his name. Number one, on what ground? So what Mr. Kirpal is from LGBTQ community. Right to love is a fundamental right. Homosexuality has now been decriminalized. So what, his partner is a Swiss national. Switzerland is a friendly country. It's not an enemy country. We reiterate his name. Even then, the president says, I'll close my eyes. I will not appoint him. So how do you ensure independence of judiciary? Another advocate was recommended by the president, by the collegium to the Madras High Court. The Supreme Court, the government said, we will not accept his candidature. Why? We will raise objections. What are these objections? He had shared an article on his Twitter which was critical of Mr. Modi. Sharing an article from quint.com which was critical to Mr. Modi, that renders you ineligible to be appointed as a judge. If that is the case, then another judge was appointed to Madras High Court. And who was this judge? Who was a member of the BJP. Who openly called for the genocide of minorities. Openly called for genocide of minorities. That person is appointed, but the person who can share the article critical of the Prime Minister, with due respect to the Prime Minister, cannot be appointed. This is not a commentary on executive. This is not the commentary on Prime Minister or the BJP. This is the sad commentary on the judiciary. You can't stand by yourself. You can't stand with your recommendations. So despite collegium system, despite the facade of independence of judiciary, executive still has the say. But now this matter is before the court again. Justice Kaul is hearing this matter, and Justice Kaul is saying enough is enough. If you will again delay it, I'm afraid we have to take it in our hands, which means right now we are giving you the formality of sending the appointment letters to the judges. Recommendation comes from collegium. You have to only appoint. If you will continue with these tactics, pick and choose, delay, not appointing, keeping the matter pending, maybe we will strip you of the appointment process as well. Maybe we will recommend names and we will ask Chief Justice of India, administer them oath and appoint them as the judges of the Supreme Court and High Court. If that would happen, that would be very scary. Because now judges would be appointed as well as oath would be administered by the Chief Justice. Formal appointment order will be issued by the Chief Justice. That goes against the doctrine of checks and balances, separation of powers. But what we need is a consensus. Genuine effort to resolve this difference between the executive and the judiciary and come up with a better MOP, memorandum of procedure, as to how these judges are to be appointed. What happens in case the executive raises objections? How these objections are to be dealt with by the collegium? If the name is reiterated, what should be the process? All this, if it is not mentioned in the constitution, which it is not, should be mentioned in this memorandum of procedure. That is how we can solve this problem. And that is how the judges are appointed. And that is how, if you have any questions, let me know. Swiss national means a citizen of Switzerland. To remove those judges as they violate constitution by striking down NJAC? No, you can't do that. Parliament can remove a judge only which we will discuss after the break, in cases of proved misbehavior or incapacity. Just because they have given a judgment, you can't remove them. We will discuss that today. Acceptable to both executive as well as judiciary. The procedure, how to appoint the Chief Justice, what are the objections to be raised, how the objections can be raised, what is the timeline within which we have to agree or disagree, then what will happen if we reiterate the name, what will happen if you will raise new objections. Clear? So that should be mentioned in this procedure. Of the Supreme Court. Those cases which can be directly filed in the Supreme Court. We say Supreme Court has the original jurisdiction on these cases. It is judicial review what is judicial activism, what is judicial overreach, what is judicial barbarism, what is judicial negation, so many concepts. But for that, you'll have to wait. There is one theory that Justice Mudholkar uh, took this concept of basic structure from Justice Cornelius of Pakistan Supreme Court, where they discuss something called the fundamental features of the Constitution. Prelims test series will start on December 24, I guess. 24. The second last Saturday of December. That's when the PTS will start. We'll discuss. Okay, let's take a break. The Chief Justice, the judges of the Supreme Court, the Chief Justice of a High Court, the judges of the High Court, they're all appointed by the President, and they can resign by submitting their resignation to the President. That's how there can be vacancy. But they can also be removed. And what is the process of removal? Constitution says a judge of the Supreme Court as well as the judge of a High Court cannot be removed from their offices except by the order of the President, passed after address in each house of the Parliament, supported by majority of the total membership of the House, and majority of not less than 2/3 of the members present and voting, and presented to the President in the same session on the grounds of proved misbehavior or incapacity. Which means, how is the judge of the Supreme Court and High Court removed? Removed by the President. That means by the order of the President. How? If both houses of the Parliament, Lok Sabha and Rajya Sabha, separately will pass a resolution by 2/3 of the members present and voting, plus majority of the total membership of the House, which means special majority, but in the same session. Which means if this motion calling for the removal of a judge was introduced in the budget session, in the same session it is to be sent to the President. That is why I told you that there is one resolution which does not lapse upon the dissolution of Lok Sabha. And that is if you are asking for the removal of a judge of the Supreme Court and High Court. So the judges of the Supreme Court and High Court can be removed by the President on the basis of the recommendation of both houses of the Parliament when they pass a resolution by special majority. But on what grounds? Grounds of proved misbehavior or incapacity. What is this proved misbehavior or incapacity? This term has not been defined in the Constitution. But what we can know of this concept of proved misbehavior or incapacity is that if somebody has indulged in misbehavior, misbehavior can be corruption, misbehavior can be sexual harassment, misbehavior can be anything. Or incapacity means when we appointed you, you were with the sane mind, sound mind. But now you have turned mentally unsound, which means you don't have the capacity to give a judgment, which means you're eligible to be removed from your office. Constitution mentions only this. But the real process, how it starts, how it is consumed, is mentioned in the law known as the Judges Inquiry Act of 1968. And what is that process? First, it can be initiated in Rajya Sabha or it can be initiated in Lok Sabha. For example, if it is to be initiated in Lok Sabha, 100 MPs of Lok Sabha should write to the Speaker that, dear Speaker, this particular judge of the Supreme Court or High Court should be removed from his office, and these are the grounds of proved misbehavior. These are the grounds of misbehavior and incapacity on the basis of which we are saying this judge should be removed. Or this process can initiate in Rajya Sabha if 50 MPs of the Rajya Sabha write to the chairperson, the Vice President of India, the chairperson of the Rajya Sabha, saying this particular judge of the Supreme Court or High Court should be removed, and these are the grounds of misbehavior or incapacity. If the chairperson accepts, first, the chairperson has to accept. This is where the discretion of the chairperson rights. It's not binding for the chairperson to accept this proposal, to accept this motion, to accept the suggestion of removing a judge. If the chairperson accepts, if the speaker accepts, then a committee will be set up. Why? Because these charges of misbehavior and incapacity, they are to be proven. How do we prove them? By setting up a committee. This committee will consist of one judge from the Supreme Court, one Chief Justice from the High Court, and one eminent jurist. And once this motion is accepted, once their report is accepted, then there is voting. That means both Lok Sabha separately and Rajya Sabha separately will pass a resolution by 2/3 majority, by the special majority. And then this resolution becomes statutory resolution. And statutory resolution is something which is binding on the government, which means the president will have to issue an order to remove that judge. Have there been cases? Yes, as well as no. No, because no judge of the Supreme Court or High Court yet has been removed from his or her office. But we have seen instances where the process has started. For example, Justice Ramaswamy. He was the judge of the Punjab and Haryana High Court. He was the Chief Justice of the Punjab and the Haryana High Court. Later on, he was promoted to the Supreme Court. He became the judge of the Supreme Court. Then there was an allegation. The allegation was that Justice Ramaswamy, when he was the Chief Justice of Punjab and Haryana High Court, he used the judicial money. He used the money which was given to him for maintaining the High Court. He used the government money to renovate his private residence, which is misbehavior, basically corruption. And then this process was initiated in Lok Sabha. When the members of the Lok Sabha wrote to the Speaker accepted this motion, set up a committee. This committee consisted of a judge of the Supreme Court, a Chief Justice of a High Court, an eminent jurist, and ultimately gave a report. And this report said, yes, the allegations of misbehavior are correct, are proven. Lok Sabha passed a resolution by special majority. When this motion was sent to Rajya Sabha, there the Congress party abstained. When the Congress party abstained, that means in Rajya Sabha we could not get the majority, and ultimately Justice Ramaswamy could not be removed. Similarly, Justice Soumitra Sen of the Calcutta High Court, he was all set to be removed, but he thought, I should not become the first judge to be removed from his office. So he resigned in anticipation of his removal. That means he was all set. There was majority also. Everybody agreed that yes, this judge should be removed. But since he decided to resign, that is how this process of removal could not be initiated. Justice Deepak Misra. He was the Chief Justice of India in 2017. And I have given you the context of Justice Misra when we discussed fundamental rights. He was part of the collegium, heading the collegium. And there were 4 senior judges of the Supreme Court who were also part of the collegium, which means Chief Justice of India, 4 senior judges of the Supreme Court. These 4 judges of the Supreme Court, Justice Chalameshwar, Justice Kurian Joseph, Justice Madan Lokur, Justice Ranjan Gogoi, they addressed a press conference in January 2017 and they said democracy is in danger. We tried to convince Chief Justice to mend his ways, but he does not act. Ultimately, we owe our debt to the society. Through media, we are telling the society that democracy is in danger. And the allegation against Justice Deepak Misra was that he is doing something known as bench fixing. Important cases he is allocating to junior judges, not to the senior judges, and ultimately this means independence of judiciary has been violated. More than 50 MPs, close to 70 MPs of the Rajya Sabha, they wrote to the chairperson of Rajya Sabha. Mr. Venkaiah Naidu was the chairperson, the Vice President of India. A motion was introduced that we have to remove the Chief Justice of India. This is for the first time in the history of independent India that a motion was tried to be introduced in Rajya Sabha or in Parliament for the removal of a sitting Chief Justice of India. But the chairperson, who has the discretion to either accept this motion or reject this motion, he decided to reject it. When he decided to reject this, ultimately no action could be taken. Justice Deepak Misra completed his term. Sir, if the chairperson rejects it, we should have an alternative. How do we go about this? For that, the alternative could have been approach the Supreme Court. And as you approach the Supreme Court, Chief Justice of India is the master of the roster. That means Chief Justice of India will get to decide who will hear this matter, because he allocates cases to different judges. That would have been violation of principles of natural justice. And ultimately, opposition decides we should not approach the Supreme Court because it will not serve any purpose. Justice Deepak Misra continued to remain in office. Long story short, the judges of the Supreme Court and High Court, they do not hold office during the pleasure of the president. They retain and remain in office till they complete a specific age. For a Supreme Court judge, the retirement age is 65 years. For a High Court judge, the retirement age is 62 years. But even before you complete your tenure, even before you retire, you can be removed. Who can remove you? President. On the basis of the resolution, statutory resolution passed by both houses of the parliament separately by special majority. On what grounds? Misbehavior and incapacity. But this is to be proved. Where? In Parliament. Judges Inquiry Act says the process that you need to follow is this. If Lok Sabha wants to initiate this process, 100 members have to write to the Speaker. If Rajya Sabha wants to initiate this, 50 members will have to write to the chairperson. And now chairperson will get to decide, will have the discretion either to admit this motion or to reject this motion. If it is admitted, then a 3-member committee will be set up, which will investigate all these allegations of misbehavior and incapacity. And basis that report, now there will be voting. If Lok Sabha passes a resolution by special majority, then Rajya Sabha passes a resolution by special majority. This statutory resolution is binding on the President of India. The President will issue the order. By notification, that judge will be removed from his office. But till date, although process has been initiated in 4 cases, but in no case could this process be culminated, which means till date, no judge of the Supreme Court or High Court has been removed under Judges Inquiry Act of 1968. But the process we have discussed. Clear? Now let's look at Article 130 of the Constitution. The seat of the Supreme Court shall sit in Delhi or in such other place or places as the Chief Justice of India may, with the approval of the President, from time to time appoint. What is the location of the Supreme Court of India? Constitution says the seat of the Supreme Court, which means the location of the Supreme Court, shall be in Delhi. But can Supreme Court sit in any other place apart from Delhi? Let's say in Chennai or other places. That means at the same time at multiple places. Delhi, Chennai, Bengaluru, Guwahati, Indore. Can it happen? Yes. Who will decide that? Who has the power to change the seat of the Supreme Court? Chief Justice of India with the approval of the President. And this is where we come across something interesting. Something interesting is, let's say we have the Supreme Court in Delhi, and we have the Supreme Court in Delhi, and I am from Kanyakumari in South India, or I am from Arunachal Pradesh, or I am from a desert area of Gujarat. I filed a case in the High Court. The High Court rejected my petition. The High Court in Tamil Nadu, the High Court in Arunachal, the High Court in Gujarat. Now, what is the option available with me? I can approach the Supreme Court, file an appeal before the Supreme Court. But where is Supreme Court? In Delhi. Now I'm calculating the costs. I, along with my lawyer, we have to go to Delhi. Boarding, lodging, food, travel tickets. And in Supreme Court, I have to appoint another lawyer. In Supreme Court, I have to appoint advocate on record, because without that advocate on record, no case can be filed in the Supreme Court. That means that lawyer, this lawyer, I am calculating the costs. Ultimately, I decide I will not approach the Supreme Court. Is this not denial of justice? It is. Making access to Supreme Court in Delhi so difficult for some people, it means you are denying them justice. The rich, the powerful, will have no problems approaching the Supreme Court. They can travel in a private jet as well, in a chartered flight as well, or they can take a normal aircraft as well. For them, there is no problem because they have money, they have resources. That means you are denying justice to weaker, marginalized, poor sections of the society. Then what is the alternative? The alternative prescribed was we should have regional benches of the Supreme Court. Which means let the Supreme Court be in Delhi. The seat of the Supreme Court can be in Delhi or in other place or places. As the Chief Justice of India, with the prior approval of the President, from time to time appoint. That means Supreme Court can sit in other place or places as well, other than Delhi as well. Let's have regional benches of the Supreme Court. Let's have a regional bench of the Supreme Court in Southern, another in Eastern, Western, and Central India. So that if there is a regional bench of the Supreme Court in Chennai, for example, people from Tamil Nadu, when they calculate cost of going to Delhi, they drop their options. They say, forget about this. We won't ask for justice because it is time consuming. It is monetary loss as well. We can't afford it. People from Tamil Nadu, Andhra Pradesh, Telangana, Karnataka, Odisha, Kerala, they will find it easy to approach a regional bench of the Supreme Court in Chennai than to approach the Supreme Court. Similarly, people from Eastern India, Western India, Central India. That means once these regional benches are constituted in 4 other locations in India, it will make justice easily accessible to the people who could not afford going to Delhi. Law Commission of India says, we agree with this. Should happen. Regional benches should be set up. State government say, we agree. Regional benches should be set up. Union Ministry says, of Law and Justice, we agree. It should happen. Bar Council of India says, we agree. It should happen. Supreme Court says, we don't agree. It should not happen. Why? Supreme Court gives 2 reasons. One, it will affect, or should we say adversely affect, the status of the Supreme Court as a national institution. Number 2, regional benches of the Supreme Court can come under the influence of local politics. Supreme Court said we may have agreed with this suggestion to set up regional benches in 4 different areas apart from Delhi so that justice becomes easily accessible. But we don't agree with the suggestion for 2 reasons. Reason number one, if we have regional benches of the Supreme Court, that means Supreme Court is not a national institution. It is now a regional institution as well. That's something which is not acceptable to us because it will adversely affect the status of Supreme Court as a national institution. Second, if we set up a regional bench in Chennai or in any place in South India, East India, West India, Central India, it will come under the influence of the local politics. That is why, for these 2 reasons, we will not have regional benches of the Supreme Court. The existing structure continues. But, my lord, if these regional benches of the Supreme Court can come under the influence of the local politics, then why don't you take an extra step and dissolve the high courts as well? Because by your logic, if we agree with it, then high courts will also come under the influence of the local politics. There should be no high court in Chennai. There should be no high court in Bengaluru. There should be no high court in Guwahati, because all these high courts, just like regional bench of the Supreme Court, can come under the influence of the regional political parties. On top of that, there is always an option of transferring a case from one high court to another. Even if we assume that in one-off case, there may be that regional bench of the Supreme Court will come under the influence of the local politics. Once you get the wind of it, once you get the hint of it, you may transfer that case to another regional bench, or you transfer that case to itself. For example, when there were allegations that these Gujarat riots cases, the Gujarat High Court is coming under the influence of the local politics, is coming under the influence of the state government. Those Gujarat riots cases were transferred to Maharashtra. When there were allegations that J. Jayalalitha's case of disproportionate assets case, where it was found or it was alleged that she has assets, she has properties which are beyond her known sources of income. If we calculate her income, she should not have bought these properties. So there is an element of corruption. When there was allegation that this case is coming under the influence of the chief minister, because this case was pending in the Madras High Court, this case was transferred from Madras to Bengaluru. That means there is always an option that if these regional benches come under the influence of the local politics, you can transfer that case from one regional bench to another or to itself. But that doesn't mean just because they may come under local influence, you will not set up regional benches. By that logic, all the high courts should also be dissolved. And I don't agree. What is the use of Supreme Court as a national institution when it is not catering to the interests of the entire nation? When people from deep south, deep northeast, deep east, and deep central India cannot access Supreme Court because it is time consuming, it is costly as well, it is expensive. That is why regional benches should be constituted. If not regional benches, then perhaps we need to reimagine Supreme Court. Reimagine in the sense, this Supreme Court, which is in Delhi, should be split into a constitutional court and a cassation court. Why? What is the difference? Today, the Supreme Court of India hears all kinds of cases. All kinds of cases. Constitutional cases. Whether right to privacy is a fundamental right or not. whether same-sex couples should be given the right to marry or not, whether Kerala governor, who is sitting on the bills passed by the Kerala Legislative Assembly, whether we can issue a directive to the Kerala governor, please pass these bills, sign these bills, or take action on these bills within a reasonable time frame. Same goes with the dispute between Telangana governor and the Telangana chief minister. Same goes with dispute between the Tamil Nadu government and the Tamil Nadu governor. Same goes with disputes involving center and the states. Same goes with disputes involving states on one side and the states on other side. For example, there is a dispute between Punjab and Haryana. So Supreme Court hears constitutional cases. Supreme Court hears fundamental rights violation cases. Supreme Court hears federal cases as well. But Supreme Court hears other cases as well. Bail applications. Whether Arnab Goswami should be given bail or not, matter goes to the Supreme Court. Whether abortion of this child, of this unborn baby, where the pregnancy is of 26 weeks or above, where the mother says, I don't want to have this child, even this case goes to the Supreme Court. Bail applications, abortion cases, family disputes, land disputes, property disputes, violation of contract disputes, all such cases reach the Supreme Court. You are choking Supreme Court. Can we split Supreme Court into two? One constitutional court, which will be in Delhi, which will only hear constitutional cases, which will hear federal cases, which will hear cases involving interpretation of the Constitution. Such cases can be filed in Delhi, and Supreme Court, Constitutional Court, will be in Delhi. But so far as other matters are concerned, where you approach the district court, then you don't get favorable verdict, you approach the High Court, then you don't get favorable verdict, you approach the Supreme Court in Delhi. For example, marital disputes, family disputes, land disputes, tax disputes, any other dispute. Such cases, instead of going to Delhi, we should go to a cassation court, which should be in 4 different locations. One in southern India, one in eastern India, one in western India, one in northern India. Because normally it is this cassation court which hears appeals against the judgments given by High Court. It is these cases which affect common man. They should be allowed to approach a regional cassation court set up in 4 different regions of India, so that Supreme Court, which is in Delhi, will hear only constitutional cases, so that Chief Justice Chandrachud and all the 33 judges, they can focus their entire attention on these constitutional cases. Today's Indian Express newspaper. 6 years, one matter was pending. Electoral bonds. 6 chief justices were present during this time. And now Supreme Court is hearing this matter. Because Supreme Court does not have time. Because Supreme Court heard Arnab Goswami as well. That lady who asked for abortion as well. Some family disputes as well. That means Supreme Court's time is now divided into various sets of cases. Can we not focus entirely on constitutional cases so that quick justice is given in these constitutional cases? Whether electoral bonds are constitutional or not, it should not take 6 years for the Supreme Court to decide. Whether the way Article 370 was diluted, was it done rightly or wrongly, it should not take 5 years for the Supreme Court to decide. Whether Citizenship Amendment Act is right or wrong, it should not take 5 years for the Supreme Court to decide. Because these are all important constitutional cases. All such cases should go to Constitutional Court in Delhi. All other appeals, where you're appealing against the High Court judgment in the Supreme Court. For that, instead of going to Delhi, you can go to a cassation court in Chennai, cassation court in Guwahati, cassation court in Bhopal, cassation court in Ahmedabad or Jaipur, wherever you want to set it up. That is how we can change and reimagine the structure of the Supreme Court. And that would be the biggest reform. But for that, the Chief Justice of India has to agree. Because the seat of the Supreme Court shall be in Delhi, That means the Supreme Court shall sit in Delhi and can sit at any other place or places as the Chief Justice of India with the approval of the President from time to time appoint. That is Article 130 of the Constitution. Any questions as of now? Questions, yes or no? What is Lok Adalat? My dear, we will reach Lok Adalats as well, but through a route. First, let's travel all these areas, then we will reach Lok Adalat. So then why this model is not coming that you discussed? This model was basically, this is not my innovation. This was given by ex-Chief Justice of India, Justice K.G. Balakrishnan. But Supreme Court did not agree. Okay. What is a court of record? We say only high courts and Supreme Court of India acts as the court of record. And only those which are courts of records can accept a public interest litigation, which we will discuss tomorrow. What is a public interest litigation? Court of record, all the high courts are court of record. Supreme Court is a court of record, and only in court of record can you file a public interest litigation. But when can we call a judicial institution as a court of record? For that, this judicial institution will have to satisfy two conditions. Condition number one, it should have the power to punish for its contempt. And we have discussed what is a contempt. Contempt is civil contempt or criminal contempt. That means if this judicial body has given an order which is willfully disobeyed by somebody, it is contempt. If this institution has given an order and there are some who scandalize the judge gave this order because he is from the same religion or same caste, or that he took bribe, or he is from the same state, casting aspersions on the Supreme Court, thereby violating the power of the Supreme Court, thereby sowing seeds of distrust and mistrust amongst the people, that they should not trust the judiciary because judiciary is not fair. Because once you attribute motives to the judges, you are planting seeds of suspicion in the minds of the people. They won't trust the judiciary. So for a court of record, one, it should have the power to punish for its contempt. Second, its judgments, proceedings, acts of the Supreme Court or this court of record are recorded for perpetual memory and testimony. These records cannot be questioned when produced before any court. What does that mean? Everything, how many amongst you are watching the live proceedings of the Supreme Court Constitution benches? Tuesday, Wednesday, Thursday, on three days, 10:30 a.m. in the morning, Supreme Court Constitution bench, 5 judges of the Supreme Court, they hear constitutional cases. And those cases are live streamed on the YouTube channel of the Supreme Court. Right now, electoral bonds, previously same-sex marriage, previously Article 370, previously Shiv Sena dispute, all these cases have been live streamed. And if you would have noticed that there are people who type everything that the judges say, everything that the individual lawyers say, everything is typed and recorded. once these records are brought before any other court or any other institution, they will not question it. They have to agree with this. And whatever proceedings, whatever judgments are given, they are stored for perpetual memory. That means the judgment of 1951, Champak Dorai Rajan, you can read it today as well. It's stored for perpetual memory. All such judicial institutions, where number one, you can punish people for contempt. Number two, if the records, judgments are stored forever for perpetual memory, and these records, once they are produced before anybody or any institution, these records cannot be questioned. Such a judicial body is a court of record. And in India, we have high courts and the Supreme Court, which act as the court of record. Because the proceedings of High Court and the Supreme Court are recorded for perpetual memory, these records cannot be questioned when produced before any other court. And they have the power to punish for its contempt. District courts, my dear, district court satisfies criteria 1, but does not satisfy criteria 2. District courts, their proceedings are also recorded, saved for perpetual memory. All the proceedings, all their judgments are recorded. But if somebody is committing contempt of a district court itself cannot punish. That doesn't mean you can commit contempt of a district court. But if you commit contempt of the district court, High Court of that state shall punish for contempt. District court asked me to be present on Friday, 12 o'clock. I am not present, deliberately. That means I am willfully disobeying a court order. I am liable for punishment. I am liable because I have committed contempt of the district court. But district court itself cannot punish me. High Court of that state can punish me for committing contempt of the district court. Because district court does not have the power to punish people for its contempt. That's not the power given to them. Which means only high courts and Supreme Court, they satisfy both these conditions. District courts satisfy only condition number 1, not the condition number 2. That means only high courts and district court act as the court of record. And only in such judicial bodies can one file a public interest litigation, which means you can't file a PIL in a district court. You can file a PIL in a high court or in the Supreme Court. And what is that PIL? We will discuss tomorrow. Now let's look at the powers of the Supreme Court, or the term that we use for it, jurisdiction of the Supreme Court. What exactly is the role played by the Supreme Court? First is the original jurisdiction. And we will add original exclusive jurisdiction. What is original exclusive jurisdiction? Those cases which can be only filed in the Supreme Court. We say Supreme Court has the exclusive jurisdiction on such cases. Is there a case, is there a type of case which you cannot file anywhere, not in the district court, not in the high court, not in any tribunal, but you can directly file and only file in the Supreme Court? Such cases, we say the Supreme Court has exclusive jurisdiction on such cases. Can you name some cases where the Supreme Court has exclusive jurisdiction? Federal cases. Dispute involving center and the state can be filed only in the Supreme Court. That means on these cases, Supreme Court has the exclusive jurisdiction. Election disputes involving president, the vice president. If there is a dispute on the election of the president or the vice president, such a dispute, such a case can be filed only in the Supreme Court. That means Supreme Court has the exclusive jurisdiction on such cases. What if there is a dispute regarding the election of the Prime Minister? That was filed where? Allahabad High Court. What if there is a dispute on the election of a legislator? Can be filed in a High Court. But when it comes to the dispute about the election of the president or the vice president, such a case can be only filed in the Supreme Court, which means Supreme Court has exclusive jurisdiction. That means it alone can hear federal cases. It alone can hear election disputes regarding president, vice president. Then we say on some cases, Supreme Court has original jurisdiction. What is this original jurisdiction? Those cases which can be filed directly in the Supreme Court and not by way of an appeal. What does that mean? There is a murder case, there is a dacoity case, there is a rape case, there is a corruption case, there is a money laundering case, there is FCRA violation case. All these cases, they are heard by the High Court. Clear? But if you are not satisfied with the judgment given by the High Court, where do you go? You approach the Supreme Court. How do you approach the Supreme Court? Through appeal. That means you're appealing before the Supreme Court. Please hear my petition because I'm not satisfied with the verdict given by the High Court. That means in these cases, Supreme Court does not have the original jurisdiction. That means these cases approach the Supreme Court through an appeal, where you are appealing against the High Court order. But those cases which can be directly filed in the Supreme Court, not through an appeal, but directly filed in the Supreme Court, we call that Supreme Court has original jurisdiction on these cases. Can you give me one big example of such cases? Violation of fundamental rights. If your fundamental rights are violated, you can directly approach the Supreme Court under Article 32 of the Constitution, called Right to Constitutional Remedy. And by this, Supreme Court will issue various writs, habeas corpus, mandamus, prohibition, certiorari, quo warranto, and protect and uphold your fundamental rights. But can you not file violation of fundamental right case in the High Court? Yes, you can. You can approach High Court. You can approach Supreme Court as well. But can these cases be directly filed in the Supreme Court? Yes, that means Supreme Court has original jurisdiction on fundamental rights violation cases, because such cases can be directly filed in the Supreme Court, not through an appeal, but directly. But can we say on fundamental rights, Supreme Court has the exclusive jurisdiction? No. Why? Because High Courts can also hear fundamental rights violation cases. That means Supreme Court does not have the exclusive jurisdiction to hear fundamental rights cases, but Supreme Court has the original jurisdiction. That means such cases can be filed directly in the Supreme Court. But those cases which can be only and only filed in the Supreme Court, we say Supreme Court has the exclusive jurisdiction on such cases. Article 131, the Supreme Court has original jurisdiction in any dispute between the Government of India and one or more states. For example, Kerala government filed a petition under Article 131 of the Constitution challenging the validity of the Citizenship Amendment Act. Although, in my understanding, it does not come under Article 131. It comes under Article 32. Why, sir? Because you allege violation of fundamental rights when CAA was passed, saying Article 14 is violated, 15 is violated, 21 is violated, secularism is violated, blah, blah, blah. So it's basically violation of fundamental rights under Article 32. Article 131 talks about a dispute between center and the state. There is no dispute between center and the state on Citizenship Amendment Act. You don't like that law. That doesn't mean there is a dispute. Dispute is if state had to provide some money to the center, but now the state has refused to give that money. Dispute is if, for example, on Delhi, or for that matter, cases involving federal disputes between center and the state, where you say that this particular area, which the central government says is now a union territory, it is not a union territory. It is part of our territory. It's part of the state. On that, there is a dispute. Such cases involving dispute between center and one or more states. For example, there is a dispute on between Maharashtra and Karnataka, as well as the union government. What is that dispute? There is Belagavi in Karnataka, also known as Belgaum. Maharashtra says it should have been part of us. Because in 1956, when the states were reorganized in the name of language, on the grounds of language. Maharashtra says when you look at Belagavi, majority of the people speak Marathi, which means Belagavi should have been part of Maharashtra, not Karnataka. Karnataka says no, Belgaum is ours. In fact, they also constructed a legislature in Belgaum. And winter session of Karnataka legislature is conducted in Belgaum. And Karnataka says that there are areas in Maharashtra, Sholapur, Kolhapur. These areas should be under Karnataka because these are Kannada speaking areas. So there are some Kannada speaking areas in Maharashtra. There are some Marathi speaking areas in Karnataka. On these areas, there is a dispute. Who will resolve this dispute? Supreme Court has the original jurisdiction. That means you can directly and exclusively file such disputes in the Supreme Court. So under Article 131 of the Constitution, the Supreme Court has the original exclusive jurisdiction on all disputes involving Government of India and states, between the Government of India and any state on one side and one or more states on the other side, between two or more states. All these federal cases can be directly and exclusively filed at the Supreme Court. So on all these cases, Supreme Court has the exclusive jurisdiction. The court has original jurisdiction when it has the authority to hear and determine a case in the first instance. That means there is violation of fundamental rights, directly approach the Supreme Court. That means the Supreme Court is hearing this matter in first instance, not through an appeal, in the first instance. The Supreme Court has original jurisdiction when it hears disputes between the two or more states. That means in the first instance, you go to the court, Supreme Court. You don't go to the Supreme Court through an appeal. But it has an exclusive jurisdiction when it has the authority to hear and determine a case which no other court can hear or determine. Which means election dispute vis-a-vis president, vice president. The Supreme Court will hear it in the first instance, not through an appeal. But Supreme Court alone can hear it. That is exclusive jurisdiction. But there are some exceptions. That means there are some cases which cannot be directly filed in the Supreme Court. One such case is treaty of a pre-constitutional era. Prior to the commencement of the Constitution in 1950, there may have been multiple treaties, agreements, sanads. For example, instrument of accession signed between the government of India and the Maharaja of Jammu and Kashmir, or the instrument of accession signed by various princely states, or the merger agreement signed by various princely states. These are all pre constitutional agreements, pre constitutional treaties. If you have a dispute on these cases, you cannot go to the Supreme Court because these are of pre constitutional era. Article 262. And what is Article 262? Interstate river water dispute. Manisha, Privy Purse was heard by the Supreme Court. Yes, because that was part of the Constitution. Constitution recognized this Privy Purse, saying 1/10 of the revenue that you had, that will be provided to you without any questions. So Supreme Court heard the abolition of Privy Purse not because it was a pre-constitutional agreement, but because it was mentioned in the Constitution. Those pre-constitutional agreements are not mentioned in the Constitution. That's why Supreme Court does not have original jurisdiction on that pre-constitutional agreement or a treaty. Article 262, interstate river water dispute, can be resolved through a mechanism which Parliament decides, but Supreme Court will not have the original jurisdiction to hear this case. Matters related to the Finance Commission. Under Article 280 of the Constitution, every 5 years, a Finance Commission is set up by the President of India. The principal job of this Finance Commission is that we have divisible pool of taxes. For example, center imposes income tax. Center imposes corporate tax. But whatever money is generated from income tax and corporate tax, will this money be used only by the center, or will it be distributed with the states? It is part of the divisible pool of taxes. That means it is to be distributed between center and the states. Surcharge, for example, cess, for example, it is not shared with the states. So when the center imposes surcharge, when the center imposes cess, those are not part of the divisible pool of taxes. That means whatever money is generated by the government of India by imposing surcharge or cess is not shared with the states. Income tax is, corporate tax is. But on what basis? What is the formula? That is decided by Finance Commission. Finance Commission said 41% of this tax will be distributed with the states. How will Finance Commission determine this? Various factors. One such factor is population. What sort of population? If your population is more, that means more money will be given to you. If a state is unable to generate its own revenue, we have to provide them more money. If there are some special category states, for example, 7 northeastern states, Sikkim, Uttarakhand, Himachal Pradesh, Jammu and Kashmir, these are all special category states, more money should be given to them. This formula is decided by Finance Commission. Now, can tomorrow a state file a case before the Supreme Court that we don't agree with the award given by the Finance Commission? Why? When we have to conduct an election to the office of the President of India, for that we follow proportional representation system? Yes. But that proportional representation system is based on the population figure? Yes. What census population figure is taken into account to determine the value of vote of an MP or an MLA? 1971 census. And we have discussed the reason why as well. Why? Because southern states were effective in controlling the population, in implementing family planning programs, and the northern states failed miserably. Which means if after the census, delimitation is carried out, that means seats are increased based on the population, northern states will see an increase in the seats Southern states, if they will not see an increase, they will not see decrease as well, but they will be stagnant, which means they will be at a disadvantage. That is why Constitution was amended. First, we will have no delimitation for the next 25 years till 2001. Sorry. Then we will have no delimitation. There will be no increase in the number of seats till 2026. And whenever we will calculate the value of vote of an MLA or an MP in president's election, we will take into account the population figures of 1971 census. But Finance Commission, when it decides that 41% of this divisible pool of taxes will be shared with the states, some states will get more money as compared to other based on population. Do you know what census population figure Finance Commission takes into account? 2011 census. That means northern states will get more money as compared to southern states because their population is more, their population is less. Can on this matter Telangana, Karnataka, Tamil Nadu, Andhra Pradesh approach the Supreme Court saying we don't agree with using 2011 census population numbers to decide the grant given by the Finance Commission? No, because this is outside the purview of the Supreme Court. This is an exception. Similarly, adjustment of certain expenses between the union and the states under Article 290. For example, prior to the commencement of the Constitution, we had the officers of the British government in India. We had some posts created by the British government in India. Now, after the Constitution, if we don't want to continue with these posts, we don't want to continue with these jobs, we will have to abolish them. But you can't randomly abolish a post. For example, you have cleared the civil services examination today. And after 20 years, the government decides that we no longer need IAS. All these IAS posts are to be dissolved. But for that, you will have to be compensated. Because once the government has decided that we are going to abolish this post, it will have to compensate the occupier of that post. For that, some money will be given. What is the amount of money that is to be given? You cannot challenge that in the court. If it was a pre-constitutional post. Long story short, all these matters deal with politics. That means these are political matters. Disputes involving pre-constitutional matter, pre-constitutional agreement or a treaty, matters related to interstate river water dispute, it's a political matter, which we have discussed yesterday, day before. Matters involving Finance Commission, it's basically a political matter. What is the kind of compensation that we provide to those posts which we have abolished? That's a political matter. And all these matters are kept outside the purview of the Supreme Court. Which means when we say original exclusive jurisdiction, when we are discussing the powers of the Supreme Court, the jurisdiction of the Supreme Court, we say first jurisdiction, first power is original jurisdiction, original exclusive jurisdiction. Original jurisdiction, those cases which can be filed directly in the Supreme Court, we say Supreme Court has original jurisdiction on these cases. Those cases which can be filed only and only in the Supreme Court, we say Supreme Court has the exclusive jurisdiction on these cases. Federal cases, exclusive jurisdiction. Fundamental rights violation cases, original jurisdiction. Election disputes vis-a-vis president, vice president, exclusive jurisdiction. But then there are exceptions. Some matters are kept outside the purview of the Supreme Court. If there is a pre-constitutional agreement or a treaty, cannot be challenged in the court. Interstate river water disputes, Supreme Court will not have the original jurisdiction. Supreme Court may have an appellate jurisdiction. That means once the award is given by the tribunal, you can approach the Supreme Court. But directly on interstate river water dispute, you cannot approach the Supreme Court. Disputes related to Finance Commission matters. On all these matters, Supreme Court does not have the original jurisdiction. Any questions? Is it permissible for my legal representative to appear in court on my behalf? Yes, that is what is their job. They have to represent you. Okay. The second is appellate jurisdiction. Appellate jurisdiction, as the name suggests, appeals. What are these appeals? You don't like the judgment given by a high court. Can you approach the Supreme Court? That means in these cases, the petitioners, they don't agree with the judgment of the high courts. On all these cases, once they reach the Supreme Court, that means we can say Supreme Court has appellate jurisdiction on these cases. That means Supreme Court is hearing these cases, not directly, but through appeal. These cases can be divided into three. Either it's a civil case, or it's a criminal case, or it is a constitutional case. What is the procedure? Listen to me carefully. This is a very technical thing that we are about to discuss now, but you don't have to be an expert to prepare for civil services exam. These questions will not be asked, but you should still have some idea, some basic idea as to how these appeals move to the Supreme Court. Otherwise, don't waste your time in digging too deep into this topic. You will become a lawyer, but unfortunately not a civil servant. Clear? So we have to look at polity from the civil services examination point of view. Even then, I'll tell you something. Even if you don't understand, but I will promise I'll make you understand. Even if you don't understand, don't worry, this question will not be asked. This matter can be a constitutional matter, civil matter, or a criminal matter. What does that mean? A boy in Kerala, a Muslim, girl, Akhila, a Hindu. Akhila converts to Islam and then marries Shefin Jahan. Father of this girl files a case that this is the classic example of love jihad. And basically, my daughter has been forced to convert to Islam, and over a period of time, she will be transported to Syria by ISIS, Islamic State. Matter went to the Kerala High Court. Kerala High Court said this marriage is void. This marriage is not legal. Akhila had later changed her name to Hadia. This marriage is not valid. And in fact, the High Court ordered that there should be investigation as to whether ISIS was responsible for this conversion or not. And this girl should be sent to a hostel, will not remain with Shefin Jahan. Matter went to the Supreme Court on an appeal. Not every case goes to the Supreme Court. Only those cases go to the Supreme Court where certificate is issued by the High Court. When Shefin Jahan lost this case, he asked, I need a certificate. I want to move the Supreme Court. Why? Because I think this is a constitutional matter. High Court issued the certificate saying this involves a constitutional matter involving interpretation of the Constitution. This certificate was given to the Supreme Court registrar that I need to file an appeal before the Supreme Court against the High Court judgment. Here is the certificate, because this certificate tells you you should hear this case because this case involves interpretation of the Constitution. This is a constitutional matter. Why is it a constitutional matter? Supreme Court said this marriage is void, this judgment is wrong. When the High Court says this marriage is void, High Court has no jurisdiction to say this matter, because this is the matter between two consenting adults. Is Akhila more than 18 years of age? Yes, she's an adult. Even if she marries a boy who is not acceptable to her family, we can't do much about this because she's an adult, the boy is an adult. And High Court is wrong in saying that this marriage is void. You can't rule this marriage void if it is between two consenting adults, if both are beyond the legal marriageable age. And in this case, the court said right to marry is a fundamental right. Under Article 21 of the Constitution. And in fact, later, this question was asked in the prelims examination as well. A right to marry comes under which of the following fundamental rights? Article 21, right to life and personal liberty. But recently, the Supreme Court has said, a 5-judge bench of the Supreme Court has said, right to marry is not a fundamental right. But be that as it may, our purpose to understand is, when you file an appeal against the High Court judgment before the Supreme Court, it's not that you directly approach the Supreme Court. It's basically you're not satisfied with the High Court verdict and then you're asking for a certificate, saying, I want to file an appeal before the Supreme Court. Without your certificate, I cannot. If the High Court thinks that yes, this case involves interpretation of the Constitution, it involves a constitutional matter, that means such matters should be heard by the Supreme Court, because Supreme Court is the final interpreter of the Constitution. Take the certificate, file an appeal, the Supreme Court will hear this appeal. That means Supreme Court has appellate jurisdiction on these constitutional matters. Sir, what if High Court will not give this certificate? Park that thought, I will come to that later. Or it can be a civil case involving a property dispute, involving a contract dispute, involving a marital dispute. All these are civilian matters. Normally, all these civilian matters die at the High Court. Most of these civilian matters die at the High Court. That means once the High Court says you are guilty or you have to pay this compensation, you have lost this case, the case is dead right then and there. But what if you want to approach the Supreme Court? Because if you're not satisfied with the High Court order, you can't go to another High Court. You have to go to the Supreme Court. Because the case involves your jurisdiction. For example, if it has happened in Bihar, the jurisdiction is that of the Patna High Court, which means Odisha High Court cannot hear this matter, which means you will have to file an appeal before the Supreme Court. But for that, High Court will have to issue the certificate. And what is that certificate? Certificate says this matter should be heard by the Supreme Court because this matter involves interpretation of a law. This is not a constitutional matter, but this matter involves interpretation of a law. Let's say Land Acquisition Act, let's say Special Marriage Act, let's say any other matter, civilian matter between two individuals. If the High Court gives you a certificate, issues you a certificate, with this certificate you take to the registrar of the Supreme Court and saying that this certificate has been issued by the High Court, it says that this matter involves interpretation of a law and as such should be heard by the Supreme Court. Supreme Court will hear an appeal. Otherwise, no. Previously, there was a limit that unless and until a case involves compensation of 20,000 rupees or more, Such cases cannot be filed on an appeal before the Supreme Court. But later on, this limit was removed. Now, any case can be filed on an appeal before the Supreme Court, provided the High Court issues the certificate. So it can be either a constitutional case, it can be a civil case, it can be a criminal case as well. Criminal case involving death penalty. If you have been charged with, let's say, waging war against the country, terrorism, rape, murder, for which death sentence is given to you by the High Court, it is your right to approach the Supreme Court. If you want, if you don't want, okay, hang. But if you want and you want to approach the Supreme Court, it becomes your right. You don't need a certificate by the High Court to approach the Supreme Court. You can directly approach the Supreme Court after this death sentence is awarded to you by the High Court. That means it becomes your right to approach the Supreme Court. But it's not an original jurisdiction, it's an appellate jurisdiction. You file an appeal against the High Court. If there is a case where the district court has sent you free, but High Court has sentenced you to 10 years or more in jail, or there is a case where the district court sentenced you to 10 years or more in jail, but High Court set you free. Such cases, through a certificate, you can approach the Supreme Court. Supreme Court will accept your petition, file an appeal, and Supreme Court will hear the appeal against this judgment, because it's a criminal matter. If it is death sentence, it's your right to approach the court. If it is any other criminal matter, for example, if district court has said you are guilty, you are given 10 years or more in jail, High Court says no, you are not guilty, you are set free, which basically means that the state will have to then approach the Supreme Court against this verdict, because state has lost. The accused is set free. The state would want the certificate, then it can approach the Supreme Court. Or if the district court says no, you are free, you're not guilty, and the High Court says you are guilty, sentenced to 10 or more years in jail, you need to take the certificate and approach the Supreme Court. So on all civil cases, criminal cases, and constitutional cases heard by the High Courts, you can file an appeal before the Supreme Court through certificate issued by the High Court, where the High Court says that this case is fit to be heard by the Supreme Court, or this case involves interpretation of the Constitution and as such should be heard by the Supreme Court, or this case involves interpretation of a law and as such should be heard by the Supreme Court. Supreme Court will hear these cases on appeal. But sir, what if High Court refuses to give the certificate? Even then, there is one exception. Under Article 136 of the Constitution, you can file a special leave petition before the Supreme Court. Cannot be treated as a right. This is the discretion of the court. Cannot be filed against the order of a military tribunal. What does that mean? Number one, if there is a case pending if there is a case decided by the High Court for which certificate is not issued, you think that this is wrong, I should have been issued a certificate, I need to approach the Supreme Court, you will file not an appeal petition. Because if you have a certificate, you can file an appeal. But this time you are asking for a special leave. That means forget that certificate, leave that certificate, please accept my appeal. That is what we call special leave petition. But this is not the right of an individual. You can't claim it as a right saying I have the right that without a certificate you have to hear my case. No, you have to convince the court that your case deserves to be heard by the Supreme Court, that this case involves interpretation of the Constitution. Because what if the High Court would have said this case does not involve the interpretation of the law or the Constitution? That is why we are not giving you a certificate. That is why the judgment says you are guilty. This case is fit to be heard by the court, by the Supreme Court. What if High Court says we will not give you that certificate? You can still approach the Supreme Court, convince it that this case should be heard because I have these reasons. That is what we call you file a special leave petition without a certificate approaching the Supreme Court. And once Supreme Court is satisfied that yes, this case indeed needs to be heard by us, it will set a date. On this date, we will hear this case. Otherwise, it will dismiss it. But this special leave cannot be filed against the order of a military tribunal. What is this military tribunal? For example, Army Act, Navy Act, Air Force Act. For example, there is an army personnel who has committed a crime. Let's say the crime is rape. Let's say the crime is murder. Let's say the crime is shooting somebody on mere suspicion. There are different tribunals there is different structure of justice for these personnel who are working in Army, Navy, or Air Force. They don't get involved in the regular civil courts. They get involved in the military tribunals. That means Armed Forces Tribunal will be set up where there will be members of the army. They will then decide whether you are guilty or not. That is what we call court martial. So if an army has committed any crime, if Air Force personnel or Navy personnel, they have committed any crime, they are not tried in the normal high courts. They are tried in the military tribunals. And these tribunals then decide whether you are guilty or not. If the tribunal has said you are guilty and you cannot file an appeal before the Supreme Court, the case is dead there. Without a certificate, you can't approach the Supreme Court. And what if this tribunal refuses to give you that certificate? You can't approach the Supreme Court. And you can't even file a special leave petition against the order of a military tribunal. That's something which is not allowed. There's an exception. So one more jurisdiction that Supreme Court has is that it can hear appeals against those cases heard by the High Court. And on all those cases, we say Supreme Court has the appellate jurisdiction. That means Supreme Court has the power to hear appeals against the judgments, verdicts given by the High Court, provided the certificate is provided. In absence of the certificate, one can still approach the court under Article 136 and call for special leave petition. You'll have to convince the Supreme Court that this case should be heard by the Supreme Court. If it is convinced, it will accept it. If it is not, then it will reject your special leave petition. But you cannot file a special leave petition against the order or a judgment given by a military tribunal. Clear? Something else. Advisory jurisdiction, which something we discussed today. Under Article 143 of the Constitution, we say Supreme Court is the advisor of the President of India. What the President can do, President can refer any matter to the Supreme Court, asking the Supreme Court to advise the President on this matter. But this matter can be broken down into two categories, two broad categories. Either it is a pre-constitutional matter or it is a post-constitutional matter. If it's a pre-constitutional matter, it is binding on the Supreme Court to give advice. If it's a post-constitutional, not binding on the Supreme Court to give advice. Advisory jurisdiction. which you will not find with the President of the United States of America. It's a unique power available with the President, that President can refer any matter to the Supreme Court, asking the Supreme Court advice on that matter. But this matter can be either pre-constitutional matter or post-constitutional matter. If it's a pre-constitutional matter, Supreme Court does not have original jurisdiction, but it has advisory jurisdiction. That means it can advise the government what to do on these matters. But if it's a pre-constitutional matter, it is binding on the president to give that advice. And if it's a post-constitutional matter, it is not binding on the president to give, on the Supreme Court to give that advice. And we have used this presidential reference multiple times. For example, in 2012, when 122 2G licenses were cancelled by the Supreme Court, 2G spectrum, right now there are talks of 6G, 5G is already there. 2G spectrum was to be sold, and for that the policy followed was first come, first serve. Policy was not auction. For example, this is the pen. What is the best way to get the best price for this pen? I will auction it. Those who want to give me 1,000 can give me 1,000. How much do you want to give it? I want to give 2,000 rupees. This person, no, this is the pen Sarmat sir uses. I will give it 5,000 rupees. Maybe. That means if I auction this resource, I will get more money. Maybe. But what if I say this is first come, first serve? I have one pen. Whoever comes for the first time takes this pen. And you tell me, I will give you 100 rupees. Okay, take and leave. 2G spectrum was sold like this. First come, first serve. You come, take spectrum, be done with this. Supreme Court said, no, this is wrong. You should have auctioned it. The way 122 2G licenses were given is wrong. 122 2G licenses are cancelled. Government was surprised. Dr. Manmohan Singh was surprised. He was the Prime Minister. He said, my job is not revenue maximization. It's the job of the government to create policy. And my policy is that this 2G spectrum I am selling on first come, first serve basis, not auction. I know if I auction this, I will get more money, but I don't need more money. I don't need revenue maximization. What I need density, teledensity. And what is that teledensity? If this 2G spectrum is sold at a lesser price, I am transferring the benefit to the consumer. How? Because if Airtel, Vodafone, Reliance, Tata, at that time it was Tata, Docomo, Reliance Communication, Airtel, Aircel, so many other carriers, if they will buy this 2G spectrum at a lesser price, that means their call rates would be lesser, SMS rates would be lesser, data rates would be lesser. When data rates are lesser, that means you are giving more incentive to the people to buy cellular phones. Because if the call rates are high, why would I buy a phone? I don't need it, for example. Now it becomes a necessity, but first you have to create a need. That means my whole purpose, according to the Prime Minister, was I don't need revenue maximization. I need teledensity to improve. And he was possibly right. Because there was a time when even if you call somebody for 1 second, you will be charged for 1 minute. And STD rates per minute used to be 2.65. If you're calling to a different carrier, different rates. If you're calling to the same carrier, different rate. Per SMS, 1 rupee if it is local. 3 rupees or 5 rupees if it is a national SMS. International, a different rate altogether. Data rates were also expensive. At that time, Edge used to work. Then came 2G, 3G, so on and so forth. But now when you see it, people are not even worried about calling. Free calls. India is one of the markets where the call rates are cheapest, where the data rates are cheapest. 200, 300 rupees, 1.5 GB per day. That's what Reliance Jio has done, thanks to Mr. Ambani, J Jio. To give him credit where it is due, he changed the market. And increasing the tele density, people have smartphones now. India is one of the biggest smartphone market of the world. Internet penetration is great, brilliant, and that has also helped solve the problems of corruption because of something known as the jam trinity. A bank account is created under Pradhan Mantri Jan Dhan Yojana, which is free account where you don't have to pay any charges. Otherwise, you have to pay charges to the bank. If the balance in your bank account is less than a specified amount, you have to pay maintenance charges because it involves money to support your account. This Jandan account is linked with Aadhaar. Aadhaar is unique and linked to mobile number as well. So that an old lady in far off northeast or deep in South India, whenever scholarship or old age pension is deposited into her bank account, she gets a notification on her mobile phone. That was the purpose. But when these 122 licenses were cancelled, the government asked the president, please use Article 143. Seek the advice of the Supreme Court. How should we sell this 122 2G licenses then? Because isn't this the policy decision? And the policy decision is that of the executive. How can you interfere with the policy? If there is corruption, you punish us. If there is no corruption, you can't say the policy is bad. That is our job. We are accountable to the people. You are not. Supreme Court gave the advice, and Supreme Court said you should go for auction when you sell this resource. You should not use first come first serve basis as the policy. Whether Supreme Court was right in saying this or not, but this is the power of the Supreme Court, advisory jurisdiction. It can advise the president on any matter. If it's a pre-constitutional matter, it is binding on the president to give, it is binding on the Supreme Court to give that advice. If it's a post-constitutional matter, Supreme Court may or may not give its advice. But whatever advice is given, is it binding on the president? No. Why? Because it's only an advice, as the name suggests. It's only an advice. But technically, it becomes binding. Normally, it's an advice because it's an advisory jurisdiction. President is asking the advice of the Supreme Court on this matter. But this is only advice. It's not binding on the president. But in technical terms, it becomes binding. Binding in the sense, 1998 was also a presidential reference, where the president asked the Supreme Court, tell us, how do we appoint the judges? Give us your advice. And Supreme Court gave a full-fledged advice. This is how you appoint Chief Justice. This is how the judges are to be appointed to the Supreme Court, to the High Court, transfer of judges. What if the government says we don't agree with this? And they will pass a law which goes against this judgment. The Supreme Court will strike it down. So although on paper it is only an advice, it's not binding on the government, not binding on the president, but technically it becomes binding. Because if you violate that advice by passing a law or by issuing an order, the Supreme Court will strike it down. Which basically means if you would still have followed first come first serve basis for selling auction, Supreme Court would have struck it down. That is why 3G was auctioned, 4G was auctioned, 5G spectrum was auctioned. First come first serve was not followed. That's advisory jurisdiction. To 10 a.m. we will discuss the remaining portions of judiciary. We will also discuss previous year's question papers. And if time permits, we will start discussion on elections. Then on Sunday, we will have a class from 6 a.m. to 11 a.m. Then on Monday, we will have the final class, which is a doubt session class between 6 to 9:30 a.m. So now 3 classes are left: Saturday, Sunday, Monday, and then polity is over. Record. When you have to file a case in the Supreme Court, who will introduce this case? That person in Supreme Court is known as Supreme Court Advocate on Record. Without his signature, you cannot file a case in the court. The court will not hear this case. 8th of November, we will have another batch. What is the difference between tribunal and court? We will discuss that tomorrow. A judge of a high court. How will the judge of a high court be selected from too many high courts? That's the discretion of the speaker, but speaker will consult the chief justice and say, please recommend somebody, a good high court judge, whom we can include in this proceeding. And ultimately, that person will be nominated.